I don't know about 15 and 16. In this matters, we are led by P.K. Gupta with Sidra Advocate, and he is indisposed. So, if the matter can be fixed on 6th of June, I have the concern of the other side regarding date also. It's a hearing date, otherwise.
No, 6th of June. Oh, June.
June.
You're right.
There will be some eye operation that.
Okay, right. On the prayer for adjournment made on behalf of Mr. P.K. Goswami, the learned senior counsel appearing for the All India Limited, who is purportedly undergoing an eye operation, list the matter on 6
of life. Admission. Meta person to hats of the field.
Huh?
Hats of the field.
What?
And Alice Miller.
Higher charge.
Yes, Miller.
Vehicle higher charge.
Yes, Miller.
Okay. So what do you want? You want to list it?
Yes, Miller.
When was it last listed?
That is the 5/8/20.
Highway 23. Give it.
Yes, Miller. It is. Can this matter be taken up after some time? And there's the senior counsel Mr. Aisha, he is in 401.
Next. No affidavit.
No, if it is actually all are keeping election related.
Huh?
Election.
What to do?
Affidavit is.
Affidavit is not here, madam.
Nothing. We are not going to cancel it also for anything.
Why will they give us for this project? Only the documents that are going to. Let's add to my.
They are disputing the position lot. They are saying that they have not taken position. We have the on record, he has stated the application lot. There are two application lots in the record. I think I have record has they have sent to me. In the application, they have stated in 2023 that he has taken a position, a part of his in hand coach.
Verify that.
No, I think it is on the record. It is as per record lot.
So there's nothing. How are you prejudiced?
Not to add to my signature.
How are you prejudiced?
What was the date? What possession? We have deposited huge amount.
When did you file the affidavit?
I will file affidavit.
When?
Uh,
You see,
May
this has
May,
the last.
after
Huh?
May 10 noted.
Why after meeting?
Noted.
Why after meeting?
Noted. May after election is there. All are on election duty lot.
All
We
right.
have only 7 staff lot. One all are terminated lot.
Okay, right.
117 employees terminated.
Mr. P. Sharma, Learned Chinese Council, AFDC, submits praise for a further,
After 10, 9 or 10 any election.
praise for a further 2 weeks time. Today is 25. This is, huh? It's 2 weeks time. No. A further 10 days time. A further 10 days time. No, 2 weeks time. To file affidavit in a position. In as much as all the staff of the AFDC is on election duty. Where there are, this is the matter on 14. Okay, 14.
At the last of
14.
Okay, it will last. Last time. Only 60.
Next. Yes, what is to be done?
The order, as per last order, this last order, there is some instruction from section where not missing kids. So, and logic,
According to you, are the highest bidder,
I am the highest bidder.
but it has been settled with the respondent number
5.
5. And has notice been, and have they appeared?
No logic. Respondent number 5 notifications are, but respondent number 5 is not appeared.
Yes.
The time of filing of this liquidation, no settlement was done.
There is no settlement. There is no
Retender
settlement.
notice was issued.
There is no settlement.
No, sir.
No settlement.
No, sir.
The period is ending in June.
June 30. Ending on June 30th. June.
What remains?
But we have an instruction.
Is he the senior? Is he the highest bidder?
He is the highest bidder,
Then-
but the issue is here that there is a website committee.
Huh?
There is a market committee of that market, where the president of the committee has given a letter to the chief executive officer requesting him to initiate a fresh tender because the
To
earlier,
initiate a fresh tender.
yes, sir.
Okay.
Because the earlier lessees you used to take lots of money from them. The toll that they used to collect from them used to be higher. And since the vendors of this market are poor farmers, and that's their attention that they are poor farmers, and that's why they are not able to give the appropriate toll to the lessee. So that's why perhaps the chief executive officer has initiated a fresh tender, but that's the incomplete instruction that we have received in the earlier.
So the second retender was issued on 3 August 2023. But after filing this case, the tender was cancelled.
Tender has been cancelled.
Lord Supreme
But that's why the retender issue was
Tender has been cancelled.
had not issued to anyone.
So you are challenging the retender.
So we are challenging the retender.
The retender dated
Dated 3/8
3/8.
2023.
But the term of the tender is only till June 24th.
24. June
What remains?
21.
as of now we don't know what the current status of the market, whether they have reissued
Huh?
resettle the market with somebody that
How can you settle the market? Isn't there a stay order?
no.
No.
No, sure. So it has been. Okay.
Worship, pursuant to the fresh tender,
So because of any settlement so made on the basis of the impugned tender notice shall be subject to the outcome of the receipt. So was it settled?
No.
It was not settled. According to you, no settlement of the market was made in pursuant to that NIT dated 3/8, 2023. In any event, supposing we set aside, there's only 2 months left, nothing else. Let them wish to affect tender, you take part. What do you say? Anna? Or did you submit your tender with regard to 3/8? No.
No. We have not
Let us see this 3/8. Where is it?
We have not participated.
Where is the NIT?
In case number 33, Lord. Annexed.
What is the period given out here? What is the period of the settlement?
40, the notice, it is informed that the Jorhat Jilla Parishad has made an instruction by letter so and so dated 31/7/2023 invite the tender of settlement of Bisubari daily market for 23-24 fresh in compliance with the decision adopted by the standing tender committee of the market. The tender for the settlement of market will be received on 11/8/2023. That is the re-tender.
It's only for till June 30th anyway. So if nothing has been settled, I think this should be set aside. Everything you say, you issue a fresh tender for the 24-25. Because now, unfortunately, this case was first listed in August. Second time it was listed was in December, and now it's listed in April. So nothing actually really survived. Correct. Heard, Mr.
SRF SRA Naftel.
S SRA
Naftel.
Naksher, Learned Counsel for the petitioner, and Mr.
U Sharma on behalf of Mr. S. Datta.
U Sharma on behalf of Mr. S. Datta,
Standing counsel.
Standing Counsel PNR.
124.
Huh?
For respondent 124.
Comma, that is the respondent number 124 and 6. Who is Ms. U Das appear for point number 3? Office note dated 29/11/23 indicates that notice was served by way of dusty service on the respondent number 5, and it was accepted by the president of the Jorhat and Dalit Panchayat. Accordingly, notice is deemed to be served upon the respondent. Next. The case of the petitioner is that a notice inviting tender dated
This is
8/5.
8/5/2023.
8/5/2023 was issued by the respondent number 5, inviting tenders for settlement of the
It's super matter.
Everybody,
where is that? Tender for settlement of the Lichubari daily market for 2023-24, that is for the period from 1/7/2023 to 30/06/2024. The petitioner participated in the tender process, and as per his information, he was the highest bidder in respect of the set NIT. Tender notice. Though the petitioner was the highest bidder, the respondent authorities, that is the respondent number 5. Is it? The respondent number, wait, no, cannot be 5. The respondent number. The respondent number 6 issued a fresh NIT dated 3/8/2023. Is it? Yeah, 3/8/2023 for settlement of the same Lichubari daily market for the year 2023-20. Being agreed, the petitioner has filed the present petition challenging the issuance of the subsequent NIT tender notice dated 3/8/2020. This court on 16/8/2023 had issued notices to the parties and had held that any settlement made on the basis of the impugned tender notice dated 3/8/2023 would be subject to the outcome of the writ petition. The tender notice dated 3/8/2023 was for settlement of the said market for the period from for the period for the 2023-24 year, which was to end on 30/06/2020. Next para. the petitioner's counsel submits that till date, no settlement of the market has been done with any person in terms of the tender notice dated 3/8/2023. Next, Mr. U. Sharma, learned counsel appearing for the respondents number 1, 2, 4, and 6. Submit that he has not received any instruction to the effect that the said market has been settled with anybody, with any person, in person to the impugned tender notice dated 3/8/2020. Okay. Next, on considering the submissions made by the counsel for the parties and keeping in view the fact that the period of settlement of the market is was to be made only till 30/06/2024. This court is of the view that due to a flux of time, it might be best if a fresh tender notice is issued for settlement of the Nishubari daily market for the year 2024-25, which is for the period from 1/7/2023 to 30/06/2025. Okay, next slide. No, continue. The counsel for the parties also agree that it would be in the interest of all if a fresh tender notice is issued. Next, enjoy the consent of the parties and as only a 2-month period exists for settlement of the market. This court is of the view that the market should not be settled with any person for the remaining 2 months period. Accordingly, the Panchayat authority shall look after the affairs of the market for the remaining period of the 2023-2024 term. The respondents accordingly directed to issue a fresh NIT for settlement of the market for the year 2024-25. Consequently, the tender notices dated 8/5/23 and 3/8/2023 are hereby set aside. Both. With petitions accordingly disposed.
Highly.
Thank you. When the matter pertains to blacklisting, the meetings are otherwise complete, it's ready for.
Will keep meeting.
The facts are like this. Nowadays, your lordship is aware for the large road construction contract, there's a consultant appointed to a tender process. The consultant more or less acts as the intermediary between the employer, that is, in this particular case, it is the NHIDCL, National Highways and Infrastructure Development Corporation, is the employer. The petitioner was appointed as a consultant pursuant to a NIT
Appointed by whom?
by NHIDCL. And thereafter, the work is actually executed by a separate process of tender, pursuant to which contractor is engaged. Now, as I was pointing out to your lordship, we act as an intermediary between the employer and the contractor. And the as the name itself suggests, let me take your lordship through some of the clauses. If your lordship will kindly take up the contract between the consultant, that is us, they refer to us as the authorities in India, and the NHIDCL is referred as the authority in this particular case. If your lordship kindly takes up the contract itself, starts at page 38. There are a few clauses that I would like to.
Page 38.
page 38. Your lordship will find in bold letters at the very top, just after Ministry of Road Transport, etc., contractor for consultant service. And if your lordship will kindly turn to first, your lordship may kindly turn to page 74. The lordship will kindly have a look at page clause 3.2. The authorities engineer shall perform the duties and exercise the authority in accordance with the provisions of this agreement, but subject to obtaining prior written approval of the authority before determining what all things D is relevant. Anything, any liability that is created beyond 50 lakh, we have to take approval of the authority. And if your lordship will kindly come to clause 3.5 of the next page, the lordship will find that our responsibility is primarily to aid and advise the authority. Clause 3.5.
These are clause or articles or what is this?
These are clauses of the contract.
What do it says out here? For a change of scope under Article 13. What is this article? What is this Article 13?
They are perhaps referring to these clauses as articles,
Perhaps will not do, no?
because I don't find any reference to the word article at first.
Let us see Article 13 or clause 13, whatever. Where is it? In your contract agreement.
It is a page 81. If it is, they are referring to clause as an article, then it will be page 80. So if there is any scope, there will be a requirement of enhancing the performance security.
Does this 3.5 relate to this 13 out here? Are you sure?
Because, my lord, if your lordship kindly comes back to page 74, your lordship will find clause 2.2 references to articles, clauses, and schedules in the terms of reference shall, except where the context otherwise requires, be deemed to be references to the articles, clauses, and schedules of the agreement, and reference to paragraph shall be deemed to be reference paragraph of this terms of reference.
No, whatever, but that may be, but then whether these are clauses or these are articles, because when you look at 3.2D,
To 39. I'm just, your lordship will just keep me one. The general conditions of contract are at page 47, and that does not make any reference to the word article. General provisions are described in page 47. Here also, I don't find any reference to word article. Either as it may, my lord, we need not detain ourselves with too much with that. I was just
then we'll have to turn a Nelson's eye to 3.5 then.
yeah, I won't even trouble your lordship with that. Your lordship may ignore it for those times. Now, my lord, If your lordship kindly comes to page 51. There is a provision for, like in all contracts, there is a provision for termination. There is a methodology prescribed
Yes.
for termination by the employer at clause 2.9.1. And 2.9.2, there is a provision for termination by the consultant. Both the parties may terminate the contract on the occurrence of certain event. And your lordship will find, unlike in many of the contracts, there is no provision for blacklisting.
One thing out here. 2.9.1 is by the client. Who is the client? The client is the contractor.
NHIT.
Acha.
We are the consultant.
He is the authority also known as the client also.
They have used the word interchangeably at various, some places as the client, some places as the authority.
Okay.
And we have been referred to as either authorities, engineer or consultant. Now, what is significant is there is no provision in many of the contracts, your lordship have noticed that there is a provision for, in the eventuality of a termination, it can be followed up by a blacklisting order. Now, I just wanted to indicate to your lordship that there is no such provision in the contract. Now, and when disputes arise, because this is one of the objections they would perhaps like to, so I am simultaneously addressing that portion also. Now, in the event of disputes arising pertaining to termination, at page 53, your lordship will find an arbitration.
Two point 9.6.
Precisely.
So now you have been terminated.
No, that is the interesting part. I have been, there is no order of termination, there is no notice, show cause notice, and out of the blue blacklist.
Where is the provision for blacklisting?
There is not. Now, the other relevant facts I must indicate to your lordship. There's a,
Yes.
the contract in question pertains to four-laning of Aji to Demo section from kilometer 491.050 to kilometer 535.250 and Demo to Bogibil junction near Lepet Kata section. This is described at paragraph 4 of the report.
It's at page 38 also it is there.
Yes.
Page 38 is the
Description.
contract.
Exactly, precise. Now, we are concerned, this was again further split up into 3 sections. These sections are, that is again, we have described at para 5. So, lordship kindly comes to paragraph 5 of the writ petition. That initially it was envisaged that there would be 2 construction contract packages for which the petitioners were required to provide consultancy services. The 2 construction contract packages would have been 4-laning of Haji kilometer so and so to so and so, 4-laning of Demo to Bogibil junction. However, subsequently the works were divided into 3 packages and the 3 different construction contracts were awarded, which were as follows. There are 3. We are, for this particular case, we are concerned with only serial number. Only this section is the proper issue. The lordship may just.
So it is within that contract
Yes.
agreement.
No, on that there is no dispute. I just wanted to indicate that with respect to the other 2, there is no problem. It is only in respect of 3. Now, with the, having split up the work into 3 separate contracts, the contract pertaining to this particular serial number 3 was initially awarded to one Messrs. Atlanta. and
Awarded to,
one Messrs Atlanta.
where is that?
This we have stated at paragraph 5 itself. And this was subsequently terminated.
Atlanta Messrs. Atlanta. Limit. Right, agreement. It says 11,260.
And this contract was terminated in 2018.
Then?
Thereafter, once again, fresh NITs were issued. And this time, one Messrs Manoranjan Brahma was appointed as the contractor. And the contract itself, your lordship will find at page 276. So in May 2019, this new contractor was engaged by NHIDCL.
This
And we got
contract agreement made between,
NHIDCL and Messrs Manoranjan Brahma for execution of the contract. And we continued as consultants. There was no problem with us. It was only the contractor who was appointed separately. Now again, in this contract, there are certain clauses which are relevant. If your lordship will kindly.
were you a part of this contract agreement? No. So how does it bind you?
There are some clauses regarding us also. If your lordship will kindly come to page 385. This is part of this contract itself. At page 380.
Yeah.
Here, your lordship will find that now they are referring to article 18. Authorities engineer, that is us.
That's okay. So that 13 that we saw there would probably refer to Article 13 of the contract agreement made between the contractor and the authority.
Correct.
In that, probably.
Now, if your lordship will kindly come to 18.1, appointment of authorities engineer.
Yes.
The authority shall appoint a firm of consulting engineers or a project monitoring committee substantially in accordance with the selection criteria set forth in Schedule N to be the engineer under this agreement. The authorities engineer. In unavoidable circumstances, authority may appoint an officer to act as authorities engineer until appointment of a consulting engineering firm, etc. Now, this is important. Subclause 2. The officer in charge of the authority, example PD, RO, CGM, these are all officers of NHIDC. Member in the case of NHAI so and so, in case of MORTH projects executed through the state PWDs and PDEP director in the case of NHIDCL. He is responsible for overall supervision and monitoring of the execution of the project as the representative of the owner of the project. Now, next sentence is very important. The authorities engineer is appointed to assist the authority for carrying out the functions as detailed under clause 18.2. So, lordship will kindly mark this. Clause 18.2, this has a significance. And again, clause 18.2 is at the bottom of that page itself. This again says that we have to do everything only with anything we do is subject to obtaining prior written approval.
Yes.
Now, your lordship may note serial number B is any additional cost to be paid to the authority by the authority to the contractor. This is subject to obtaining their approval. Now, next subclause E, any other matter which is not specified in A, B, C, or D above and which creates financial liability on either party. This is subject to approval of the NHIDC. Now, next subclause 2 is very important. No decision or communication of the authorities engineer shall be effective or valid unless it is accompanied by an attested true copy of the approval of the authority for and in respect of any matter specified in 18.21. So, no decision or communication shall be effective without a valid, unless it is accompanied by a approval. Now, these are the relevant clauses of the contract. Now, if your lordship will, there is another important document which I must point out to your lordship, which is at page 476. And then I'll come to the facts of the
476, yes,
477.
unreadable.
In reference to, as my lord got it.
I've got it. You should have given a legible copy.
But is it not legible? In
It's,
my,
yeah, it is at my full of dots and,
I won't trouble your lordship with the entire page in that case, my lord. From this document, I just wanted to point out that
let me see your copy.
my English also, as well as
There seems to be a better statement.
your lordship may have it.
No,
I'll
it's
just-
okay, it's okay, you read, you
I
read.
mark the relevant portion, your lordship.
Just read it, just read.
This order was issued by NHIDCL. Because there were certain cases, your lordship is aware, when a contract is being executed, there are interim payments, part payments made from time to time. And in certain cases, it came to the notice that there are instances of some excess payment at the interim stage. So what this order does is it casts a responsibility not only on the consultant, but also on the officers who are at site supervising for NHID. That please be careful. Henceforth, if it is found that excess payments are being made, in that case, both the consultant as well as the officers will be responsible. It is for just this purpose I wanted to point out, because it has a relevance as I proceed. Now,
Please read, where is it, written?
para 3,
Where?
para 3. I'll read it very slowly. Issues of overpayments in certain cases have been brought to the notice of NHIDCL headquarters. The reports of overpayments are examined at headquarters expeditiously, and strictest action shall be taken against erring authorities, engineer and officials. GM, DGMs at PMUs and ED are supposed to check and review the progress report submitted by authorities, engineer at periodic interval, and should verify the record through periodic inspection, including inspection at the time of interim stage payment. Now, in the instant case, what happened, your lordship? Yes, read one more, just read one. Issues of overpayment in certain cases have been brought to the notice of NHIDCL headquarters. The reports of overpayments are examined at the headquarters expedition, and strictest action shall be taken against erring authorities, engineer, that is the consultant, and officials. Officials will be of the NHIDCL. GMs and DGMs at PMUs and ED field, these are all officers of NHIDCL, are supposed to check and review the progress report submitted by authorities, engineer at periodic interval, and should verify the record through periodic inspection, including inspection at the time of interim stage payment. So it casts an obligation on the officers of NHIDCL to inspect and only thereafter approve the payment.
But it also casts some responsibility on the
Consultant, certainly. We, in a sense, what we do is we supervise the work and we make recommendations that this much of work is executed, and we make a recommendation that payment can be released. Based on that, they do their own verifications, inspections, etc. And thereafter, once it is approved, only then payments are released to the contractor. And in this particular case, apparently what happened, during the peak of COVID, when movements were totally restricted, naturally, there was some restrictions on us, our officer also, the consultant. Apparently, this Manoranjan Brahma, he raised some bills in excess of the actually executed work. And this happened, your lordship may just make a note of the period, my lord. I will point out from the record itself. And we have made these statements at paragraph 9. It's a longish paragraph. Your lordship may just make a note. Paragraph 9 at pages 13, 14, and 15. This Messrs. Manoranjan Brahma,
Paragraph 9
paragraph 9
of the writ petition.
of the writ.
Yes.
The period is important one. May 2020, which was the absolute peak of COVID, till June 2020.
But June 2021 is not so much. Basically, 2020 was the
2020 was it, but gradually it started getting relaxed. Your lordship is aware of those when we used to have these particles. That is when we started gradually coming back to court towards 2020. Now, this was the stage. Apparently, he raised some excess, and perhaps our officers at site, they had their own handicap. Now, they also recommended some of the things. But ultimately, it was for the authorities, unless they approve, it is their money. The responsibility of inspecting and approving is on them. Ultimately, be that as it may, payments were released, which apparently turned out to be at that interim stage. It turned out to be little bit in excess. Now, there were communications exchanged. One of the communications your lordship will find at page 470. We get this letter from NHIDCL. And this is how it reads. Very short letter.
Yes.
It is dated 26th of September 2022. Subject, four laning of end of Moran bypass, etc., etc. Now, sir, please refer to PMO Dibrugarh's letter dated 24/9/22, cited under reference, and copy enclosed by which your letter dated 22/9/2022 pertaining to implementation of the project has been enclosed. The contents of your letter dated 22/9/2022 have been broadly perused, and it appears that there is a difference in the work physically executed at site and the amount released to EPC contractor. The details have been enclosed as annexed to your letter dated so and so. So it is from my letter that they are getting to know. As per the terms of reference of the consultancy services agreement, the AE shall determine the amount due to the EPC contractor and recommend the release. You will also just make a note of this word recommend. Recommend the release of the amount. During the various site visits and by letter dated 10/8/2022 and 15/9/2022, it was conveyed that the physical progress at site vis-a-vis the same reported by the AE does not appear visually at ground. Further, this office by its letter dated 25/5/2021 had also instructed to ensure financial prudence at the highest level. Despite the above, the AE took a substantial time to reconcile the details. So, which means the details have been reconciled by us, indicating its poor record keeping and non-professional way of working despite having key sub-key personnel and support staff at its disposal. Further, the details have also been reconciled FPS IPC wise,
not been reconciled.
has also not been reconciled, which was also instructed by this office letter dated 15/9/2022. In view of the above, you are hereby instructed to deliberate the reasons which warranted the AE to recommend such payments to the authority. The reply is to be submitted to this office within 7 days from the date of its close. We get this letter and we respond in detail at page 473. We received this earlier letter by NHIDCL is 26/9/2022, and our letter is dated 3rd of October 2022. Now, this is how we respond. Kindly refer to the above correspondence and various discussions we had on the subject matter from time to time. In response to your letter dated 26/9/2022, we are herewith providing our replies in the following paragraph for your kind perusal. We do not agree with your statement in the letter under reference that the authority engineer has poor record keeping and non-professional way of working. During the meeting held on 29/7/2022 at Dibrugarh, under the chairmanship of Director Technical, it was informed to us that the physical progress of site vis-a-vis reported by AE does not appear visually at ground. Accordingly, we were asked to reconcile the physical work done at site vis-a-vis payment release. Accordingly, our team members available at site carried out the physical verification of the work executed at site vis-a-vis payment released to EPC contractor. It was ascertained by our team members that following works were though not executed fully at site, but payment was released. Now, in the next page, in the form of a chart, we have given. Further, during the meeting held on 17/8/22 at RO Guwahati, under the chairmanship of Director of Technical, the following targets were set for EPC contractor to be achieved by 15/9/22. We have closely monitored the progress.
What is this EPC?
Uh-uh. I'll just. Engineering, procurement, and construction.
That is the contractor.
We have closely monitored the progress of site and ensured that the above set target was achieved by the EPC contractor. In this regard, we have been reporting the progress on daily basis to the authority. RO Guwahati, by its letter number so-and-so dated 15/9/2022, further asked us to reconcile the statement of physical work done at site and payment release thereof. Accordingly, we have asked our team at site to carry out the detailed reconciliation work in consultation with the DBM and NHIDC. Based on the outcome of the said exercise, we have submitted our response by letter number so-and-so dated 22/9/22. From the available records and information and also discussions with Mr. Harbhajan Singh, the then team leader, and other site staff deployed at relevant time, we understand that the deviation from the said procedure was due to the tremendous pressure from officers of authority at field unit to achieve the target set by the then management of NHIDCL to book the funds allocated. The above is further fructified from the fact that the officers in charge of authority also visited the site prior to release of the payment and endorsed the work at site without stating any observation, comment with regard to any discrepancy. Detailed analysis of overpayment SPS IPC wise reveals that most of the overpayment released to the EPC contractor was during the period from May 20 to June 2021, i.e. during the period of COVID-19 pandemic time, when there were real-time challenges at site, especially for physical inspection verification. It is pertinent to mention here that exceptional urgency was noted in releasing the payment to EPC contractor without giving sufficient time to authority engineer to reconcile, verify the bills submitted by EPC contractor. We further understand that the team leader of authority engineer was instructed to bring the SPS IPC submitted by EPC contractor to the authority on the same date or latest by next day. Details of submission of bill and sanction dates thereof as mentioned below clearly depict the urgency and release of the payment. Your lordship will kindly see the date. Date of
How does it matter? How does the dates matter?
dates. What we are trying to say is firstly, there is this COVID-19 pandemic.
But that is there.
And
But that justify a wrong measurement being taken?
I'm not trying to justify. I'm just trying to point out how we responded. We said two things, that your lordship knows that there are funds which lapse by the end of the financial year. Now, if the authorities put pressure,
I don't know. This is not a government department.
it is
It's
a government corporation.
it's a government corporation, but whether the funds lapse, I don't know. Whether that is an issue
I
here.
am not even going into all that. What I'm trying to say is, on the one hand, there is this pandemic related issues. We have our own challenges. And we are merely a recommendatory authority, recommending authority. Now, assuming this is a long ongoing project at the time of making interim payment.
You are not giving undue importance to yourself. The very reason that you are there as a consultant.
I am not shirking my responsibility even for a minute. I am just to give an example. Now, when a selection committee conducts a selection and makes its recommendation, the appointing authority is never bound by it. It is more of a recommendation. For good and sufficient reason, the appointing authority can deviate from the recommendation. And here, express power is conferred on the authority, that is the NHIDC, that you will inspect and you will approve whatever recommendations come from the consultant. You will inspect, carry out inspection, and then you will approve. And only thereafter payments will be released. Now, my lord, these all the details we furnish. And if your lordship kindly turns to the next page, page 475, this fact is very important.
But then, out here, approved payment, no doubt, but that is beyond 50 lakh. Below 50 lakh or up to 50 lakh will depend entirely upon you.
No, this has been further modified in the subsequent contract. I'm sorry, in that case, I perhaps overlooked to point that out. If your lordship will kindly come to page 385.
55.
The same clause where it says 50 lakh, that stood modified by virtue of this. With the new contract being signed with Messrs. Manoranjan Brahma, the same clause your lordship will find that 50 lakhs limit is not there. It simply says any additional cost to be paid by the authority to the contractor. Page 385, right at the bottom. And E, subclause E, any other matter which is not specified in A, B, C, or D above, which creates financial liability on either party. So any financial liability that gets created, we will need a prior approval of the. Otherwise, they are the holders of the money. NHIDCL is the authority who has the money and who will release the payment. Now, coming back to the page 475, our reply, one fact is very important. Page 475, the third paragraph from bottom, your lordship will kindly see. After having explained the whole thing, we bring to your kind notice that part of the extra amounts so paid to the contractor has been already adjusted, and the balance amount will soon be adjusted in full from the works which are under progress. So, because these excess, there might be excess payment, but these are interim payments. These can always be adjusted because it's an ongoing contract, and that is what exactly we did. The moment it came to our notice, we found that there has been some discrepancy.
It came to the notice of the company, I mean, to the authority, and then they brought it to your notice. If it had not been done,
No.
Huh?
Your lordship will kindly come back to their letter. Page 470.
470.
We
Yes.
First paragraph itself.
Yes.
Please refer to PMU Dibrugarh's letter dated so and so, cited under reference, and copy enclosed by which your letter dated 22/9/22 pertaining to the implementation of the project has been enclosed. The contents of your letter dated 22/9/22 have been broadly perused, and it appears that there is a difference in the work. We brought it to their notice that there appears to be some.
No, let us see this letter. 22/9/22.
This has not been.
That is the crux.
If necessary, it is a part of the records, they can always produce it.
No, but
But-
since this is your case, it is your case that this anomaly in the figures, in the payment made,
But-
was brought to the notice of the authority by you.
Even
That
assuming-
that document should have been here. in the-
We'll try to balance. In any case, my lord, it is they who are saying, if your lordship will kindly peruse the second sentence of that paragraph.
Yes, sir.
The contents of your letter dated 22/9/22 have been broadly perused, and it appears that there is a difference in the work physically executed at site and amount released to the EPC fund. So it is our letter dated 22/9 from which it appeared that there is a difference. And when we responded, we gave the full details. If your lordship, now in this context, if your lordship comes back to page 472,
Yes,
in this context, if your lordship now comes back to our reply, your lordship will find that we gave full details, chart, we prepared charts, that these are the areas with respect of which excess payments have been made. We gave the full details of the dates of payments, etc., etc. And thereafter, my lord, we say at page 475 that now having come to the notice, it has adjustments have already started, and some of the excess payments have already been adjusted, and even the balance will shortly be done later. Now, my lord, from this letter, after we give this letter, they issue another letter to us, page 478. Again, a short, very short letter from the NHIDCL to us. Subject is again core lending, etc., etc. Now, first they refer to their earlier letter dated 26/9/22. Please refer to this office's letter dated 26/9/22, by which it was instructed to deliberate the reasons which warranted the AE to recommend payments for works which were not physically executed at site within 7 days, etc. In this regard, while letter dated 3/10/2022, a reply has been furnished from your end. The reply has been perused and it has been noted that the reasons for recommending payments for works which were not physically executed at site have been described to be attributable to the authority in the light of the provisions of clause 18(1)(2) of the EPC-PA. Further, it has also been stated that on account of the tremendous pressure of the authority, the bills were recommended on the same day or latest by the next day, and adequate scrutiny couldn't be carried out at AE's end. The reply which has been furnished is nothing but absurd. Being the administrator of the EPCCA, selective reading and improper interpretation of EPCCA cannot be accepted.
EPC will be
That engineering, procurement, and
the contractor. The contractor. The contractor unit. And CA is the contractor.
contract agreement.
Contractor.
By stating that as the bills were recommended on the same date or latest by the next day, with adequate scrutiny at your end was not clearly indicates the failure of the system based on which your team was operating at site, considering the excess of calculation required for recommending payment. Okay. The fact that the record keeping of your team score is also reinforced by the fact that it is FPS by the consideration of the work.
SPS meaning?
Stage payment system.
Huh?
Stage payment step.
State payment step.
Stage payment.
Stage payment step.
Statement.
Statement. Stage payment step.
Interim payment. In view of the above, an opportunity is again being extended to deliberate the reasons which warranted the AE to recommend such payments to the authority. The appropriate reply to be submitted to this office within 7 days from the date of issue of this letter. Further, an appears by statement of they do not, your lordship, see the contents of the letter. They do not even refer to the actual details that they simply say that since we have tried to put some burden on the authority, it's more of a language itself shows that it's more of a ego. Now, what again, this we furnish another detailed reply, which your lordship will find at page 480. And this runs into several pages, ends at page 484, and we deal with. They are primarily trying to say that our record keeping is poor. So to drive home that point, so lordship see that page 480, we make it a heading, poor record keeping, and next page your lordship will find we keep full details of from the record. And we proceed on to this is so far as the core record keeping is concerned. Then we proceed to page 482. The other, although it is difficult to even call it any kind of an allegation, but they said that our reply was absurd. Calling A's letter date as so and so is absurd. Again, we deal with it. Paragraph wise. And thereafter, my lord, at page 483, the lordship will find the heading reasons for overpayments to the contractor. Again, we explain. And next page, last page 484. We again reiterate. In view of the facts explained above, the reasons for overpayment to the contractor are not acceptable for a case. They are accepted by the officers. Now, your lordship knows the moment we try to point these things out, they start taking it on their egos. Please, once they get this letter, now page 487 is the issue. Without even issuing a so-called notice, straight away. And this makes very interesting reading. They have written about 5 pages. They do not even deal with the facts and figures that we have given. They do not even deal with the fact that your lordship may make a note of this. But I won't trouble with a very longish order. One of the most important facts that is not bothered to deal with is the fact that judgments have are ongoing and they are almost complete. So there is no actual loss to the and in any case, there is no even paying allegation that I benefited in the case. In fact,
But that is not the issue. The issue is you were supposed to do your job. But you did not do your job properly, due to which there was excess payment made for jobs not done. Now, that has subsequently come to light on the basis of your letter or their letter, I do not know, or whatever. But the fact remains is that you did not do your job properly due to COVID or whatever reason. So now, after, you see, say a thief, if he's caught, usually he gives back whatever is still left in his pocket or tries to make do to lessen the thing. So that is one way of looking at it all.
here, my lord, at best, if we
Out here, you're not the thief.
exact,
You're not the thief. Only thing is that you were supposed to do a certain job in a certain way. Unfortunately, you were slightly lax in your scrutiny or superintendence of the work in question, due to which they had overpaid. It has been adjusted due to it being found out. If it was not found out, then they would have made a loss.
it is our due diligence. Your lordship sees their letter and the content of our responses to them. We are the ones who are pointing out that this is the area where we have identified.
So we will have to see those.
Your
Then
lordship so desire and explain
one of them is that letter dated 22/9.
Yes.
We have to see that.
they are trying to check. Now, madam, if your lordship kindly comes to order of department.
This is a department notice or is it a
They call
department?
it a notice, but they have already departed. That will be clear from page 491. The lordship comes to 491.
Yes.
Although they are calling it a notice, but they have already imposed the penalty in para 15. In light of the above, Messrs. Boyne Solutions, etc., in association with Ashika Consulting Private Limited, is hereby debarred for a period of not even a so-called notice. And your lordship may, subject to correction by my learned friend, your lordship, I am not troubling your lordship with the whole order. Your lordship may make a note of one fact, that they do not deal with any of the facts and figures that we give. They do not deal with the responsibilities that, yes, we might have made a wrong recommendation, but no payment could have been released had you not approved. That aspect is not even there. They could have, but ultimately, these are all human intervention, there might be some mistake in calculation. To follow and this human element not been there, there would not have been an appeal to a division bench and appeal to the Supreme Court. It is for these reasons that these checks and balances exist in the system. That is why in the contract itself it is made that we are merely a recommendatory body. We are supposed to supervise the board, that equality board is next. And at the stage of making payment, we make recommendations, and these recommendations are further inspected, examined by the authority. After that, since they are the custodians of the money, they on the money being released, it gets paid to the contractor. Now, to take away without even issuing a proposal whether it's permissible. However, for that, two more important factual aspects of the matter. One is,
How much time are you going to take? You have already taken an hour.
actually, another 2-3 minutes, and then I'll come.
How quick complete within 10 minutes?
Always expect time.
How much time?
Not a person.
How many judgments?
When a- But, your workers will take a, is capital rate. Running pay, 550.
Whose affidavit?
Then affidavit filed-
NHIDCL.
Return file back. It is of paragraph B of paragraph 4. Just one short sentence I want to point out.
Yes.
The last sentence of that of paragraph B.
Yes.
As on 11/7/23, the progress is 65.29%. This is the physical progress of the work that they are.
Where is it?
522. Of paragraph B last sentence.
The length of the project is 19.175 feet.
The length of the project is 19.175 kilometers. It will complete the project of 4/12/21.
Ah,
As
as on,
As on 11/7/23, the progress is 65.9%. Now in this context, page 544. The part of paragraph 8 of our affidavit five,
yes, 544.
544, towards the bottom of paragraph of that page, your lordship will find from the record, the financial payout to the contractor is 60.17.
Yes.
In fact, the actual physical progress is more than the financial capacity.
I don't know whether this has got any relevance.
This follows just.
It depends upon the rate. It depends upon what type of work you have completed.
That will come as.
Because if it's an item rate contract, it will depend upon
These are records, I cannot do
because
anything about.
completion, maybe 68 or say 90% off. But then the
Make it clear. The interim payments are paid with the extent of 90%. 10% are always reserved. It is at the final when the work is completed.
that's a different, that's a
So therefore,
different.
under- that was the physical power 65 and the each factor is point. So that's a 10% every time is retained.
Now, there's another important fact. It's ultimate.
This para 8, wait, para 8, this page 544. I don't know what relevance it has.
I want to point out just one thing. These excess payments that there were some excess payments made from May, May 2020, 2021. What I wanted to point out from this fact is that the necessary adjustments are already made, and
No.
there was no excess payment.
I think you know where it's that you see, when you're constructing a building or if I say a building, the you might have completed say 80% of the work. But the cost for that 80% of the work might be just 60% of the estimated price of. It is not that you get that because you have completed 80% of the work, that you have used up 80% of the estimated cost price. That is not the way it functions.
There
It depends.
always a
It depends upon the item on what it is used.
and also there will also be different, obviously, Manoj,
Item.
payment. Always your lordship gets so many repetition asking for payment of outstanding. There are situations in that contract gets executed over a long period of time. There will be these pluses and minuses.
Yes. So it depends upon the item. If it's an item rate
Various
contract, yes, it is factorial.
Various.
So this has got no relevance according to me.
We have filed an additional affidavit. This contractor method, Manoranjan Brahma, his work was ultimately terminated. They found, initial cases found that his work was not up to the mark of that. But they ultimately terminated. The reason why I am pointing out this is we have from the moment we came to, we have faced this on record. In the notice of termination, this allegation of going the person actually who would have benefited, that allegation does not exist. He has been terminated for different reasons. That allegation that he, because ultimate beneficiary would have been him. We assuming we made a mistake, but the actual beneficiary, physically money would have gone to him. That allegation even if the notice does not. And that manner we have based on record by way of an additional affidavit. I will quickly point that out to your lordship. Starts at page 562.
Yeah.
The affidavit starts at 562 and the notice the termination policy termination subject is 568. This will indicate it is addressed to Manoranjan, authorized signatory of Manoranjan Brahma. That is the contractor who actually executed the work. From page 569, there is a factual narration. And page 573, the relevant paragraph is paragraph 28. They record the grounds on which the termination has been. And your lordship will not find the ground of excess drawal of bills as a ground for termination of his contract.
There were other grounds, maybe they thought.
Actually, it does not exist. That would have been because he would have undue gain, assuming my mistake or my whatever one may call it, my role. But the ultimate beneficiary, actual financial beneficiary would have been the contractor. And that ground does not even exist. So this is one factual aspect I wanted to bring to your lordship's notice. And now, Manoj, I can proceed to my submission. My first submission is neither the contractor nor any officer has been penalized because I am only a recommending authority. The beneficiary is the contractor and the approving authority is the officers of the department. And my statement to this effect, your lordship will find we have made a categorical statement at paragraph 14 of the writ petition. if your lordship will kindly have the relevant portion, it's a slightly longish paragraph, I won't trouble your lordship. I'll just read out the relevant sentence. Page 21 of the. This is part of paragraph 14.
Yeah.
Fifth line from top, your lordship will find the sentence starting, however. However, surprisingly,
Paragraph 14.
it is a continuation of paragraph 14 and page number 21.
Page number 22. Okay. Yes.
Fifth line from top. However, surprisingly, the petitioner has been singled out, making it a scapegoat and is sought to be penalized for the purported excess payment made to the EPC contractor without there being any fault on its part. The petitioner has been singled out and made a scapegoat by leaving off the EPC contractor as well as the officials of the authority. So this is my categorical stand. And your subjective correction, my lord, they have not even disputed this in their affidavit.
But neither have you denied the fact that there was excess payment.
I cannot make black into white, white into black. What I'm trying to say is there is no, firstly, they have not even given me a show cause notice, making an allegation, specific allegation. Secondly, there is no indication that I did it for any malafide intention. So, assuming there is a human error on my part, it's a long contract, it's a small phase of a few months when there are some excess payments. I have made, assuming made a mistake. But there were various checks and balances. If I am at fault, the person who benefited from it and the person who authorized the payment, they are equally at fault. I am only a recommending.
They are equally at fault.
So to that extent, my lord, my submission, to that extent, there is a clear violation of Article 14.
Does that mean that they have singled you out? But then there's nothing wrong in singling you out.
Your lordship will record my submission, my lord. That is all I can.
I'm just saying.
My lord,
If there are three persons who have told a lie, one person is caught and he is penalized. For that.
just to give you an example, my lord. A person, the example that fell from your lord, the thief who actually benefited, and I play some kind of an intermediary role. The thief is not even caught, not even penalized, is allowed to go. The person who authorized, allowed the thief to steal, he is allowed to. And I am the person who is the intermediary is got hold of and penalized by nothing less, blacklisting. And your lordship is aware of the law, right, from European equipment. The Supreme Court has time and again said that it entails one of the worst consequences. It entails civil consequences. So therefore, it should be always as a last resort. In fact, their own circular they have, if I may place that also.
No, you see out here, it's not a question of whether you steal or you did not steal. Basically, what they're saying is that you were negligent and you did not do your job properly. That's what they basically.
And without even notice to show cause.
Those are different issues.
If your lordship will kindly have a look at their own circular, page 497, just for a moment. This is the government of India's Ministry of Finance manual for procurement of consultancy and other services.
Yeah.
And if your lordship kindly turns to 509.
Yeah. Yes.
Down below, your lordship will find a clause 2.4.4.
Yes.
Safeguarding procuring entities' interests during debarment of supplier, contractor, consultant, service provider. Suppliers, contractors, consultants, service providers are important assets for the procuring entities, and punishing delinquent suppliers, contractors, consultants, service providers should be the last resort. This is what I
Yes.
wanted to point out. It takes a lot of time and effort to develop, register, and mature a new supplier. In case of shortage of suppliers, contractors, consultants, service providers in a particular group of materials equipment, such punishment may also hurt the interest of procuring entities. Therefore, views of the concerned department may always be sought about the repercussions of such punitive action on the continuity of the procurement. Past records of performance of the supplier may also be given due weightage. In case of shortage of suppliers, contractors, consultants, service providers, and in
Those
case-
are all right. Those are different.
My-
Hey, what else? What else?
My lord, so
What else?
firstly, my lord, they have violated their own circular. Secondly, my lord, I have been singled out without any action being initiated against either the contractor or the officer, which again their own circular says that they would do, they should do. Now, my lord, coming to the law, first, my lord, let me place Eurasian equipment. And that the fact remains that whatever excess payments were there, that has been recovered. So there is no actual loss to NHID. If your lordship will kindly have Eurasian equipment. This is 1975 1 SCC 70. This is the case when the apex court said that this entails a very serious civil consequence. Therefore, notice is a must. Your lordship will first come to para 12.
Yeah.
Under Article 298 of the Constitution, the executive power of the Union and the state shall extend to the carrying on of any trade and to the acquisition, holding, and disposal of property and the making of contracts for any purpose. The state can carry on executive functions by making a law or without making a law. The exercise of such powers and functions in trade by the state is subject to Part 3 of the Constitution. Article 14 speaks of equality before the law and equal protection of the laws. Equality of opportunity should apply to matters of public contract. The state has the right to trade. The state has the right, the duty to observe equality. An ordinary individual can choose not to deal with any person. The government cannot choose to exclude persons by discrimination. The order of blacklisting has the effect of depriving a person of equality of opportunity in the matter of public contract. A person who is on the approved list is unable to enter into advantageous relations with the government because of the order of blacklisting. A person who has been dealing with the government in the matter of sale and purchase of material has a legitimate interest or expectation. When the state acts to the prejudice of a person, it has to be supported by legality. Now, next 15 months. The blacklisting order does not pertain to any particular contract. The blacklisting order involves civil consequences. It casts a slur. It creates a barrier between the persons blacklisted and the government in the matter of transaction. The blacklists are instruments of coercion. Now coming to my para 17. The government is a government of laws and not of men. It is true that neither the petitioner nor the respondent has any right to enter into a contract, but they are entitled to equal treatment with others who offer tender or quotations for the purchase of the goods. This privilege arises because it is the government which is trading with the public, and the democratic form of the government demands equality and absence of arbitrariness and discrimination in such transactions. Hofield treats privileges as a form of liberty as opposed to a duty. The activities of the government
Okay,
have a
basically para 21. That's what they said.
17 and also 20. Last sentence of that para 17. Reputation is a part of person's character and personality. Blacklisting tarnishes one's reputation. Now, para 20, blacklisting has the effect of preventing a person from the privilege and advantage of entering into lawful relationship with the government for purposes of gain. The fact that the disability is created by the order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to represent his case before he is put on the blacklist. And thereafter, my lord, para 21, your lord. Now, my lord, in Eurasian equipment, Supreme Court made it mandatory that opportunity, adequate opportunity has to be given. Thereafter, my lord, what was noticed over a period of time, how the law developed, my lord, what was noticed is just as a formality, they would issue a notice. And without actually adhering to what a notice actually should be. That is when, my lord, the next judgment came. This is Gorkha Security Service. 2014, 9 SCC 105.
Para.
The relevant paragraphs that I'm relying on are 16, 21, and 22, which lays down the law. And in the context of this case, which is also relevant, paragraphs 24 to 28. Your Lordship may first turn to para 16. It is a common case of the party that the blacklisting has to be preceded by a show cause notice. Law in this regard is firmly grounded and does not even demand much amplification. So what the Supreme Court says is this is laid down. Now, next one. The necessity of compliance with the principles of natural justice by giving the opportunity to the person against whom action of blacklisting is sought to be taken has a valid and solid rationale behind it. With blacklisting, many civil and evil consequences follow. It is described as civil deaths of a person who is frustrated with the order of blacklisting. Such an order is stigmatic in nature and debars such a person from participating in government tender, which means precluding him from the award of government contract. Now, if your Lordship will kindly turn to para 21. Thereafter, my lord, various case laws are discussed. I am not troubling your Lordship. Your Lordship may come to para 21. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind the serving of a show cause notice is to make the noticee understand the precise case set up against him, which he has to meet. This would require the statement of imputation detailing out the alleged breaches and defaults he has committed, so that he gets an opportunity to rebut the same. Another requirement, according to us, is the nature of action which is proposed to be taken for such a breach. That should also be stated so that the noticee is able to point out that the proposed action is not warranted in the given case, even if defaults, breaches complained of are not satisfactorily explained. When it comes to blacklisting, this requirement becomes all the more imperative, having regard to the fact that it is harshest possible action. Now, if your Lordship kindly turns to para 22. The High Court has simply stated that the purpose of show cause notice is primarily to enable the noticee to meet the grounds on which the action is proposed against him. No doubt the High Court is justified to this extent. However, it is equally important to mention as to what would be the consequence if the noticee does not satisfactorily meet the grounds on which an action is proposed. To put it otherwise, we are of the opinion that in order to fulfill the requirements of principles of natural justice, a show cause notice should meet the following two requirements. The material grounds to be stated, which according to the department necessitate an action. Number two, particular penalty action which is proposed to be taken. It is this second requirement which the High Court has failed to. Now, accordingly, they proceed. Now, here again, what had happened in the case before the apex court is narrated in paragraphs 24 to 28. If your Lordship kindly comes to para 24, it would be necessary to take note of the relevant portion of the clause 27 of the NIC under which umbrage is taken by the respondent to justify their action and even appeal to the High Court. Under clause 27A reads as under, In case contractor fails to commence execute the work as stipulated in the agreement or unsatisfactory performance or does not meet the statutory requirements of the contract, department reserves the right to impose penalty as detailed below. Number one, we are not concerned with. Number two, the first liberty granted is to cancel the contract and follow it up with a blacklisting order. And this is the shelter that was being taken by the authorities in this particular case. And what the apex court held in this context, your lordship has skipped para 25, para 26 describes. In the present case, it is obvious that action is taken as provided in subclause 2. Under this clause, as is clear from the reading thereof, the department has a right to cancel the contract and withhold the agreement. That has been done. The department has also a right to get the job which was to be carried out by the defaulting contractor to be carried out from other contractors. In such an event, the department also has the right to recover the difference from the defaulting contractor. This clause no doubt gives further right to the department to blacklist the contractor for a period of 4 years and also forfeit his earnest money security deposit. It is thus apparent that this subclause provides for various actions which can be taken and penalties which can be imposed by the department. In such a situation, which action the department proposes to take need to be specifically stated in the show cause notice. It becomes all the more important when the action of blacklisting and of record forfeiture of earnest money security deposit is to be taken, as the clause stipulates that such an action can be taken if so warranted. The words if so warranted thus assume great significance. It would show that it is not necessary for the department to resort to penalty of blacklisting or forfeiture of earnest money security deposit in all cases, even if there is such a power. It is left to the department to inflict any penalty or not depending upon as to whether circumstances in a particular case warrant such penalty. There has to be due application of mind by the authority competent to impose the penalty on these aspects. Therefore, merely because of the reason that clause 27 empowers the department to impose such a penalty would not mean that this specific penalty can be imposed without putting the defaulter contractor to notice to this effect. So in this particular contract, the reason why I wanted to point this paragraph out to your lordship is in the case before the apex court, there was an express provision in the contract itself for blacklisting. In spite of that, the apex court said that you could not have, you have to disclose clearly in your proposed notice, firstly, the specific allegation and the grounds on which you intend to take action. And secondly, you have to disclose clearly that this is the action that we propose to take against. Because the right as your lot, this is very similar to the right under so far as disciplinary proceedings are concerned. Unless the officer is specifically informed that this is the specific allegation against you, this is the specific charge against you, and we propose to take so and so penalty. Firstly, he has a right of disputing it on merit. And secondly, when it comes to the second limb, assuming I have committed this, still you ought not to impose this penalty on. These are the two rights, my lord. And thereafter, my lord, a very recent judgment, UMC Technologies. This is reported in 2021. Volume 2 SCC 55. And I'm relying on paragraphs 13, 14, 20, and 20.
13, 14.
20 and 20. After this word, I won't. This is the last judgment. At the outset, para 13. At the outset, it must be noted that it is the first principle of civilized jurisprudence that a person against whom any action is sought to be taken or whose right or interests are being affected should be given a reasonable opportunity to defend himself. The basic principle of natural justice is that before adjudication starts, the authority concerned should give to the affected party a notice of the case against him so that he can defend him. Such notice should be adequate and the grounds necessitating action and the penalty action proposed should be mentioned specifically and unambiguously. An order traveling beyond the bounds of notice is impermissible and without jurisdiction to that extent. This court in Nazir Ahmed, etc., has held that it is essential for the notice to specify the particular grounds on the basis of which an action proposed to be taken so as to enable the noticee to answer the case against him. If these conditions are not satisfied, the person cannot be said to have been granted any reasonable opportunity of being heard. Specifically in the context of blacklisting of a person or an entity by the state or a state corporation, the requirement of a valid, particularized, and unambiguous show cause notice is particularly crucial due to the severe consequences of blacklisting and the stigmatization that accrues to the person entity being blacklisted. Here it may be gainful to describe the concept of blacklisting and the graveness of the consequences occasioned by it. Blacklisting has the effect of denying a person of or an entity the privilege or a privileged opportunity of entering into government contract. This privilege arises because it is the state who is the counterparty in government contract, and as such, every eligible person is to be afforded an equal opportunity to participate in such contract without arbitrariness and discrimination. Not only does blacklisting take away this privilege, it also tarnishes the blacklisted person's reputation and brings the person's character into question. Blacklisting also has long-lasting civil consequences for the future business prospects of the blacklisted person. Now, if your lordship will kindly turn to para 20. In the present case, the factum of service of show cause notice dated so and so by the corporation upon the appellant is not in dispute. Pausing here for a moment, my lord, in our case, notice has not even been given. Rather, what Shri Banerjee has argued on behalf of the appellant is that the contents of the said show cause notice.
Okay, I have read it. I have read it. Next.
So therefore, my lord, on this count, my lord, case, in my humble understanding, it is squarely covered. There is no notice itself. Since there is no notice, obviously, my lord, the ingredients of a notice that are required, as has been held in Gorkha,
The contents of the notice.
that is, the question does not even. So on this limited question on law itself, this petition can be answered. And my lord, one point has been taken, technical point has been taken, I won't even trouble your lordship, that there exists an alternative remedy, etc. In a case of blacklisting, it affects Article 21. So I'm not even troubling your lordship with Whirlpool and all the other judgments. And just one submission on that point, if they at all make that submission. Each of these case laws that I placed, the Supreme Court never sent it for arbitration or so that itself goes to show that remedy. Can I be excused for 2 minutes?
Listen, before you start, there is one very pertinent question that has been raised. Number one is that there is no notice issue. I think that's an admitted fact. You might say that this amounts to a notice at best. Okay, assuming that it is a notice, those letters, the proposed action of the debarment is not at all spelled out in any of those letters, which is not in consonance with the judgment cited, where it has been stated that the contents of the notice would require not only the materials that are going to be relied upon you to say that he has not acted, diligently. And number two, that the proposed penalty or action to be taken is blacklisting / debarment. Now, what have you got to say to that? Only on that point. Whether, assuming that the letters that you send is a notice, is there any mention that if he has not been able to answer properly or explain properly the excess payment made, he was likely to be debarred from participating in any other project with the NHIDC for 2 years?
So first of all, your lordship is fine, it was 10,
Hmm.
678.
Hmm.
Performance
They paid
page 70.
78.
the last clause, the 10, performance clause.
Yes.
Authority engineer shall be expected to fully comply with all the provisions of the terms of reference and shall be fully responsible for supervising the design, construction, and maintenance and operation of the facility takes place in accordance with the provisions of the EPC contract agreement and the schedules. Any failure of the authority engineer in notifying to employer and the contractor on non-compliance of the provisions of EPC contract agreement and other scheduled by EPC contractor, not adherence to the provisions of terms of reference and not adherence to the time schedule prescribed under terms of reference shall amount to non-compliance. The clause, my lord, in the agreement. Now, how it is to be done, my lord, that is by
Okay. Assuming you're correct, he has not performed. And
now, how he'll be declared as for the non-performer that.
No,
covered by-
how he will be declared, the end result is that you want this court to understand that he was a non-performer. And accordingly, he has to be declared a non-performer and for which he was debarred. Okay, supposing this court agrees with you fully, he is a non-performer, he did not perform as per clause 10. And he was rightfully declared a non-performer. The first question that comes to mind is, what penalty can be imposed on a non-performer? Does it include debarment?
It's already gone.
Let us see that.
That's what, no, that guidelines, my lord, how, my lord, the person, the contractor would be, my lord, declared non-performer, that is governed by a circular, that is, you will find it 492,
849.
490.
I think you know how this case is going to end up, it appears. So please, don't take too much time. You give whatever you have.
Yes, yes, I'll come to
There was
those
no point.
also, my lord, here,
Because at the end of the day, we have to again go into the issue of notice.
so I'll confine to that only.
492, yes, this.
Yes, 490, so this is the circular which governs, my lord, how to declare, my lord, contractor, non-perform. Now, let's make on the 495, my lord, different grounds of non-performer as mentioned here.
495, yes.
But this 493 onwards, my lord, different, my lord, instances have been given for which non-performer can be declared, then you will come to 495.
Yes, yes.
Clause 5.
Yes.
Before deciding a AEI, CSC, PNC as non-performer or regarding penalizing it, the concerned authority shall issue a notice to the AE so-and-so by giving 15 days time to furnish its written reply and allow personal hearing if so desired by
Shall
the-
issue a notice.
Well, yes, madam. Issue a notice to written reply. The authority has not, well, by now has not finalized, determined that he'll be penalized or he'll be debarred. They have certain views in their mind, so they are asking the, well, written reply that these are the things. So what do you have to say on that?
Okay, so that debarment notice is only a notice according to you.
This is the notice.
It is not a, it
So
is,
those notice as such, my lord, that unless you give the written reply, you
wait, let us read the debarment notice. Whether it is a notice or not. According to you, it is a notice. It is not a penalty order.
it is page 470.
Page 487.
470.
470.
470.
470 is a
Yeah.
show cause notice.
They have mentioned so called notice that initiated from that. I'll come to that.
Now let us see the show cause notice.
Yes, 470.
Does it say anywhere that you are liable to be debarred?
No.
So
470.
this cannot be a show cause notice as contemplated by the Supreme Court for debarment or blacklisting of a person.
This is the process that has been given in the notice that as his explanation.
Correct, but then that has been now clarified by the Supreme Court that if you're going to blacklist the person, the following requirements are also be required to be added in the notice.
Well, these are the factually all those cases can be restricted erosion as well as this Gurkha security. I'll come to that. In Gurkha security, the multiple penalties were there. They have been shown a particular penalty as to why you should not be doing that. But that particular clause contains many other penalties. Ultimately, they have penalized him for the blacklisting, not the one which was told in the so-called notice. So therefore, whatever penalty you want to impose, you must show that was the penalty consentment. Here you are also find the notification does not tentatively at till that time while asking the explanation, they are just proceeding towards the inquiry. It is basically an inquiry. So they have given an opportunity to explain what they have to say. This is page 470.
Page 470 is not a show cause notice.
This is
As-
notice. So it is mentioned.
You know, the word is notice, but not the notice that is contemplated by the Supreme Court.
But that would be different context, and the different issue. Here with the particular this circular is governing. In erosion, that erosion, the factually the person had against him certain adverse comments were there in a previous tender contract. So authority kept in their mind, and whenever he submits the subsequent tender, he is being debarred because of the earlier this adverse comment. So court says this amount to blacklisting, so the person concerned ought to have been given the so-called notice. That is the erosion. And even this order of non-performance is not final as per this circular. In a sense, my lord, because there itself is given the review power. The person can approach for review.
Let us see 489. 490.
490.
Not 490, wait, for the department, 487.
487 is development.
487.
Yes, that is the final order. 487.
487 is the final order.
Prior to that, he has been given opportunity to explain the matters, number of occasions. And starting with
Okay, so according to you, 470 is the notice, page 470 is the show cause notice, correct?
notice.
Any other notice?
Yes.
Show me which other notice. So
Well,
according to you, page 470 is the show cause notice.
470 is followed by 472 reply by him.
No, I'm not on that. I want to know that those are replies. Those are communication.
Continuation.
Those are no. According to you, there are show cause notice as a continuation, they reply to the show cause. And then the second show cause, any other second show cause submitted by you? No.
Four 78.
Page 470.
478. This is also in continuation.
478 is a community. This is not a show cause, no, is it? What is it?
This is reminder, madam. This is continuation, reminder.
Okay, this is a reminder of the show cause.
Yes, madam. Under decision inquiry, it is noted.
No, so you said this is part of the show cause. This is a continuing show cause.
Yes, madam, we find the circular, madam, has, madam, stated.
Just a minute, just a minute. I just want to know the facts first. Then we'll go to the circular. Continuing show cause
Madam, so first
notice dated 26/9/2022.
madam, 470 is the first,
I know. That is of
so first
26/9/22.
followed by his reply, madam,
Followed by his reply.
reply.
Reply is
That
reply is page. Reply
Reply is at 472.
472. And then there's a continuing show cause at 478.
Then we were not satisfied. Then again, he was given this reminder at 478.
A reminder.
Of his reply.
Ah. And then he gave a reply.
He gave a reply.
Page 480. 480, correct? A reply. Dated 7/11.
478. Then it is followed by 7/11/22. Page
Yes, yes, page 480.
480. And here your lordship will find 481. He has admitted this 11.95311759 has been admitted by him. Yes, my lord. Clearly says above wise detail revealed that overpayment released to the EPC contractor was during the period so and so, so and so. It is to be noted that excess payment released to contractor over a period of 1 year cannot be without the appropriate consent of the authority at field limit. Field limit. There is a field limit is there. Sir. So this is an admission, and this same admission has been made even in the Malad paragraph 9. He has admitted that yes,
Are you a counsel at the back? Mr. Abir? Huh? Okay. For a counsel without ban.
now this is 480 is the Malad his
Okay, let us go to your circular. That is at page
and again Malad 485.
485.
Then again 485.
What is 485?
Malad he was suitably fine. What is 485? Please refer to your letter dated 7/11/22 by which you have submitted FTS wise reconciled statement for the subject mentioned project, wherein it was reported that 11.95 crore was paid in excess to the EPC contractor. In this regard, it is requested to submit the time-wise executed quantities against the total scope of the item as on date, physical progress, and percentage range. Then he replies to it, page 486. What it says, Bharat, in this regard, I would like to inform you that our team at site is checking and compiling the requested information and we will be submitting the same in due course. Then finally, we have issued this, Bharat, page 487,
There's the department notice, the blacklisting.
23/1/23. Now, the particular circular here, Lordship will find, Bharat, page 492.
Yes.
And in the development, the development order, your lordship will find page 491. What is the conclusion?
490?
491, paragraph 14.
Yes.
Whereas team leader, resident engineer, and so of Iron Solution Private Limited in association with the Africa Construction Service has not followed the role and responsibilities as defined in the contract agreement signed between NHIDCL with the Africa Construction. So therefore, not that he has misappropriated the money, but then he has failed to discharge his duty and responsibility. Now, 492 is the circular. I said, 493 onwards, various other instances for which non-performance can be given. 495.
Yes.
Before deciding, well, they have not decided as yet, but before deciding, AE, that is the writ petitioner and others, as non-performer or debarring, penalizing, it the concerned authority shall issue a notice to AE so and so by giving 15 days time to furnish its written reply and allow personal hearing if so desired by the AE before the competent authority or any person designated for the purpose. Such a notice shall not be issued without the approval of an officer not below the rank of so and so. In case of projects where publicly safe and engendered between behavior, conduct, action of the consultant, the authority may temporarily suspend the consultant from participating in ongoing future meeting up to 1 month period during which the regular process of development shall be concluded. Now here it is only a written
Okay,
reply.
let me, what is this? Shall not be issued without the approval of an officer not below the rank of chief engineer slash CGM. What is CGM?
Chief
Chief General Manager
But all the
slash ED.
all
So that means they're equivalent, all this. ED is what?
the-
Executive? Executive director. So,
so that different is they have approved. They have
no, no, no.
order. I think.
You see, without the approval of an officer not below the rank of first, in case of
These approvals were
the competent authority for approval of penal action would be the DG, RD, NESS, respect of sensor.
now you're looking at clause 7. It is very important. Madam.
Yes.
The firm individual on which penal development action is taken may represent to the review authority against the action penalty imposed. The reviewing authority shall be the secretary RTH in respect of NH work being implemented through the state PWD. NHAI and NHIDCL will designate competent authority for deciding penal action at the reviewing authority. Upon declaration of the non-performance, the AE will not be able to participate in any bid of national highway project with MOD or any other executive agency till such time the development persists or the AEC is removed from the list of non-performers. AEC shall include its JV partner promoters with credentials were considered while qualifying them for the project. Non-performer development status of the bidder on the bid due date will be the criteria of eligibility of a bidder to participate in the said bid. So, this, all this, the authority that has been mentioned that their approval is required, it has been obtained before issuing the non-performance order. Non-performer, this and debarring him from this two, the order. For that, the all the authority.
So your case is that show cause notice has been issued.
As required, notice has been issued, and any doubt that had arisen, we have further given him the opportunity to explain. So question of whether violation of principle of natural justice does not arise. He has given an ample opportunity, and what he has done, he has admitted that yes, 11.95 crores got released.
How much was released?
11.95 11.95 here.
Where is that?
Page 481, his own admission. Page 481. It is his explanation. And he admitted this has been done. But then because of the COVID, this had arisen. That is the only explanation he has given there. And thereafter, for further clarification, the subsequent notices were issued to him that he clarified that. And then ultimately,
Has it been reconciled? The amount?
yes,
Yes. Has it been reconciled?
as I said, the interim payments are made to the extent of 90%.
Mr. Counsel, there is a simple question. Has the amount been reconciled?
Yes. Because the termination payment, on termination of the contract, when the EPC contractor, contract was terminated. At that time, there is a.
Okay, let me ask you another thing. Whatever they do, the petitioners, they are supposed to only have a recommendatory effect unless you give permission to them in writing, approval to them in writing. Now the agreement that was made between you and that Brahma, where it also talks about the role of the petitioner. Now those conditions are binding upon the petitioner. It will supersede the conditions imposed. Will it supersede the conditions imposed between you and the petitioner? The contract made between you and the petitioner. You see, there was a contract agreement made between you and the petitioner earlier, prior to the contract being advertised and allotted to the contractor. Subsequent to that contract agreement, this Brahma has been appointed. Now,
He's
the-
executing contract.
he is the executive contractor. Naturally, there's only one executive contractor. So that contract,
There are three pieces were.
correct, but I'm talking about Brahma. I'm not talking about any other XYZ. So Brahma, in Brahma's contract agreement with you, the role of the petitioner has been slightly made different in terms of the contract agreement made between you and Brahma, vis-a-vis the contract made between you and the petitioner. So which will have primacy?
So first, his contract with us.
But then you had made an agreement with Brahma saying the role of the petitioner will be this.
But he is having a contract with us for the three of the project. Three of the project that different.
So my question is, can you have a provision made with some other persons affecting him?
We are basically, perhaps don't matter, we are relying on the contract that was executed by the official. So it is.
Any other thing? I basically I know your case now. Your basic case is that as per the circular, of 2021, read with clause 10 of that performance clause, the petitioner has been declared a non-performer after issuing notice to him. And that debarment notice, that impugned debarment notice is basically the final order. Correct? He's been debarred and he has been found to be a non-performer. So, and the fact is that he has admitted to the fact that there has been excess payment for work not done. So nothing remains. That is the thing.
And my lord, apart from the, even if he is not satisfied with that, there is also a clause, my lord.
And there's alternative remedy available.
Now the whole question here, my lord, is the violation of principle of natural justice, whether the natural justice, whatever. So called notice is only given to that effect. Now, on the basis of the fact admitted, even if your lordship directs to issue a so-called notice, can he improve what he has more to say?
You mean to say that no prejudice is caused to him?
No prejudice has been caused to it. So MC Mehta, Aligarh, the event mother is yes, Dharampal Satyapal case.
Yes.
Yes. I'll just give the reference of the cases.
I know MC Mehta, no notice. Probably you're talking about that EPCIL or EPC, that P. Karunakar, those cases. Give me the citation and
Melody Dharampal Satyapal Melody 2015 AIR SCW 3882
FCW,
3882.
Mera,
I can just keep this it's already written here.
I've got the entire thing, judgment.
In that case, paragraph paragraph 39, 40, 49, and 45.
45?
Sorry.
It's only up till 41.
Oh, I'm sorry, Melody, it's 31, 35, 36, and 38. 31,
31,
31, 35, 36, and 38. Also 39. I may read out paragraph 38. Mary. In the present case, the issue relates to giving of notice before taking action. While emphasizing that the principles of natural justice cannot be applied in a straightforward formula, if aforesaid instances are given, we have highlighted the jurisprudential basis of adhering to the principle of natural justice, which are grounded on the doctrine of procedural fairness, accuracy of outcome leading to general social goals, etc. Nevertheless, there may be situations where for some reason, perhaps because the evidence against the individual is thought to be utterly compelling, it is felt that a fair hearing would make no difference, meaning that a hearing would not change the ultimate conclusion reached by the decision maker, then no legal duty to supply a hearing arises. Such an approach was endorsed by Lord Wilberforce in Malloch versus Aberdeen Corporation, who said that a breach of procedure cannot give rise to a remedy in the court unless behind it there is something of substance which has been lost by the failure. The court does not act in vain. Relying on this comment, Brandon L.J. opined in Cinnamon versus British Airport Authority that no one can complain of not being given an opportunity to make representation if such an opportunity would have availed him nothing. In such a situation where procedure appears to serve no purpose, since right result can be secured without according such treatment to the individual. In this behalf, we need to notice one other exception which has been carved out to the aforesaid principle by the courts. Even if it is found by the court that there is violation of principle of natural justice, the court have held that it may not be necessary to strike down the action and refer the matter back to the authority to take fresh decision after complying with the procedural requirement in those cases where non-grant of hearing has not caused any prejudice to the person against whom the action taken. Therefore, every violation of the concepts of natural justice may not lead to the conclusion that order passed is always null and void. The validity of order has to be decided on the touchstone of prejudice. The ultimate test is always same. The test of prejudice or the test of fairness. Then 35. At the same time, it cannot be denied that as far as court are concerned, they are empowered to consider as to whether any purpose would be served in remanding the case, keeping in mind whether any prejudice is caused to the person against whom the action is taken. It is so clarified in ECR that 36. Keeping in view the aforesaid principle in mind, we are going to find that there is an infraction of principles of natural justice. We have to address a further question as to whether any purpose would be served in remitting the case to the authority to express demand of amount recoverable only after issuance of notice to the appellant. In the fact of the present case, we find that such an exercise will be totally detailed having regard to the law later by the the law has been laid down in the particular case in the RC tobacco case. So therefore, court did not remand it back. That the 38 in escort funds. So this court, while reiterating the position that the roots of natural justice are to be followed by the substantial justice, held that at the same time it would be no use if it amounts to compelling a mere ritual of a hearing without possibility of any change in the decision of the case on merit.
Yes,
As well as the MC Mehta, AIR 1999, Supreme Court 5
yes.
paragraph 23.
Paragraph 22. Yes.
It is therefore clear that if on the admitted or undisputable factual position only one conclusion is possible and permissible, the court need not issue it merely because there is violation of principle of justice. Now here,
Yes.
the excess payment has been admitted in violation of the terms of the agreement. Then, this alleged of AIR 2000 code 2783.
Yes.
Paragraph 24, 24, 25, 26,
24, 26.
24, 25, 26, 27, 29, and 30.
29 and
30.
yes.
Paragraph 24. It uses formality theory. It must be noted as an exception. Apart from the class of cases of admitted or indisputable facts leading only to one conclusion referred to above, there has been considerable debate of the application of that theory in other cases. The divergent views expressed in regard to this theory have been elaborated, considered by this court in MC Mehta 1958 referred to above. This court surveyed the view expressed in various judgments of doing so. It's the same difficulty.
So basically, he's saying notice is required, you are saying notice is not required. Because he has admitted to the fact.
He is saying that notice is required by incorporating what punishment would be incorporated on. Now here is the case. Please notice that the
You see, I'll just read out one portion of the judgment of the Supreme Court. It talks about the contents of the show cause notice.
Yes.
When it comes to blacklisting, this requirement becomes all the more imperative having regard to the fact that it is the harshest possible act. Categorically, because it says here, when it comes to blacklisting, it has not said any other reason. When it comes to blacklisting, specifically that.
that issue has been based on the fact of that particular case.
Correct. That this fact is what? Out here it is debarment is what? It's blacklisting.
Well, the debarment, my lord,
What is the difference between debarment and
debarment
blacklisting?
has been defined here. What would be the, what would, my lord, would make a, my lord,
What is the
conduct
difference? Tell me the difference.
Then a procedure has been given by the
You
circuit.
see, the Supreme Court has also said, with regard to even if it is a law, this has to be followed. Whereas I read it somewhere. even if some, even if some guidelines or something has been made, this has to be followed. Anyway, that is what I find.
But that's what the distinction can be made only on the fact of that case. And here, my lord, the procedure has been prescribed by that particular circular. That is not under challenge. He has not challenged that this particular notice, contemplates of issuance of a slow person. It is just a written reply. It is a written reply.
It does, that circular also does not say the contents of what the notice should be. Does it clarify that this should be the contents of a notice?
No, my
Supreme Court has clarified that what the contents of a show cause notice should be.
Hello?
Especially in cases of blacklisting.
now fine, but this even if this after the coming into conclusion by this particular department notice that we have issued. Now the formality should be only to issue him as to why we should not.
You take a fresh, you issue him a fresh notice.
That's what would it not be a useless formality? On the
I cannot help
facts.
it, Mr. Counselor. I am only a High Court judge, single bench, and I have got the Supreme Court judgment right in front of me. What am I to do? Can I say that the judgment is of a useless formality? Supreme Court judgment is of a useless formality. Can I say that?
But I have referred to the judgment.
Correct. But then this judgment has specifically stated when it comes to blacklisting, no other thing. When it comes, it has talked about contents of a show cause notice in general. And at the end, it has said, when it comes to blacklisting, comma, this requirement becomes all the more imperative, comma. And then it ends with another 5-6 words it ends. Now, can I say that this is a useless formality?
Look, on the facts of this case, my lord,
On the back of this case,
yes,
on the back-
11.95 crores have been, my lord,
okay, I've heard. I think I've basically what I've heard. I think, right.
taken as per the circular method. There's a power on the, he has an opportunity for dealing and review.
Correct. But
So
then,
we can-
but
we can- we
where
can
is
go
the
for
bar? Where is the bar for this court to decide this issue when the law has been laid down by the Supreme Court?
And Whirlpool, man. Whirlpool paragraph 1459.
Whirlpool, you did not give me.
Just give the citation. I think I placed the judgment in another case before.
Maybe.
I'll just place, give the citation. 1998, 8 SCC, page 1, and relevant paragraphs are 14, 15. And there are those conditions laid out that if there is violation of fundamental rights, violation of natural justice, your lordship.
Oh, that, okay.
And in any case, my lord, 226, it is only a discretion of sending it to. It is not a mandatory.
Okay, right. Right. Mr. Indrajit Chaudhary, Learned Counsel for the petitioner. Assisted by Mr.
Yes, Mr. Gaurav.
Also heard Mr. P.J. Saikya, Learned Senior Counsel for the respondent.
No, all the
Only one response. All response. Assisted by Mr. R.K. Talukdar. The petitioners are aggrieved. The petitioner, one, no? The petitioner is aggrieved by the department notice dated, impugned department notice dated 23/1/23, issued by the National Highway Infrastructure Development Corporation Limited, bracket NHIDC, by which the petitioner has been debarred for 2 years for participating in any future project of the NHIDC. slash MORT and H, comma, either directly or indirectly. In accordance with para 3, bracket 3, bracket A and bracket E, small e, MORTH circular dated 7/10/2021. The petitioners counsel submit that the petitioner is the consultant slash authority engineer in respect of providing consultancy services for the contract work pertaining to bracket invert comma 4 laning of Janji to Demo section DEMOW section from KM 491.050 to KM 535.250 and Demo to Bogibeel Junction near Lapet Kata section from KM 535.250 to KM 581.700 of NH 37 in the state of Assam under SARDP-NE on engineering, procurement and construction bracket EPC bracket close mode inverted comma close which was bifurcated into 3 contracts. Full stop. The department notice has been issued in pursuant to the contract that is END of Moran bypass bracket KM 562.525 bracket close to Bogibeel Junction bracket KM 581.7. The petitioners challenge to the department slash blacklisting order is basically on the ground that no notice had been issued to the petitioner prior to the impugned debarment notice being issued. He also submits that there was no termination of the petitioner's. Was there any termination?
Long ago, we don't call 5122.
Terminate. Okay, then we won't go into that issue. Next. There is a provision for blacklisting act. That's
Even
circular.
the law is
Yeah, I know. Anyway, but since that we have taken that down, I will not mention it. Next para. Mr. PJ Saikya, learned senior counsel for the respondent, on the other hand, submit that show cause notice was issued to the petitioner prior to the impugned debarment slash blacklisting order was issued. He further submit that as there was an admission on the part of the petitioner with regard to the fact that excess payment had been made to the contractor for work that had not been executed. Is it? For works that have not been executed, there was no prejudice is caused. No prejudice can be said to be caused, even if no notice was issued to the petitioner prior to the issuance of the show cause. Acha, before that, we just right, Mr. Indrajit, right? The petitioner's counsel has relied upon. No, in support of his submission, the petitioner's counsel has relied upon the judgments of the Supreme Court in the case of Dash versus Dash 1971, 1 SEC 70, or 1975, 1 SEC 70, then number 2, 2014, 9 SEC 105, then number 3, 2021, 2 SEC 551, and number 4, 1998, 8 SEC 1. Then with the PJ Cycle, right? In support of his submission, he has relied upon the judgments of the Supreme Court in the case of 2015 AIR SCW 3884, number 2 AIR 1999 SC 2583, and number 3 AIR 2000 SC 278. That's all. That's all. One more thing. He further submits before that. He further submits that he further submits that the blacklisting of the petitioner can be put to challenge by way of a review in terms of the circular numbers 7, 10, dated circular dated 7/10/2020. And as such, the petitioner should avail of the efficacious alternative remedy available.
What was judgment, my lord? AI 1977 Supreme Court.
Number 4, AIR 9. To the same effect.
Well,
You mean to say the more is better?
the case is clarified the matter erosion equipment case, saying that that was at the threshold. Once the agreement
no,
is entered in between.
There are judgments subsequent to Eurasian. There are judgments subsequent to that. I'm not that Eurasian judgment is of 1975. Look, there are judgments 2014
And 21.
and 21. 2014 and 20, that 21 judgment has also relied upon 2014. So, okay. You see, there's no point.
This is the three judges bench, but it's
How does it matter? This is specifically on a specific point. It is on a specific point. There's something called judgments made on the general facts and circumstances of the case, but this is on a specific issue. There's no point, you can always go to the DB and yes, wherever. Then next, I have heard to learn counsel for the party. The brief facts of the case is that in respect of the contract work, inverted commas, end of Moran bypass, bracket KM 562.525, that goes to Bogeybeal Junction, KM 581.700, comma. Tender notice was issued and consequently the contract was awarded. The contract for construction of the road was awarded to one MS Atlanta or Atlanta? ATL Atlanta Limited. By agreement dated 11/2/2016. The said contract was, however, terminated on 2018 and a fresh NIT was issued. In pursuance to the fresh NIT, a contract agreement was entered between the NHIDCL and MS Manoranjan Prama for the said contract. As the contractor had raised bills beyond actually executed works which were supervised by the petitioner, which was supervised by the petitioner, and which was also which was supervised by the petitioner. No, don't say that. This is the contractor raised bills beyond actually executed work. The said bills were to be scrutinized and verified by the petitioner, and consequently, and recommendation made, and recommendation made. The said recommendation was thereafter to be further scrutinized by the NHIDCL. The fact remains that the bills were cleared, the contractor's bills were cleared, and payments beyond actually executed work paid to the contractor, to the contractor. Subsequent to the said fact, communications were made between the NHIDCL and the petitioner on coming on the parties coming to learn that there had been payment of bills beyond actually executed. In this respect, the first letter with regard to the first letter with regard to the excess payment made is reflected in the show cause notice dated 26/9/2022 issued by the NHIDCL.
That is what is my complaint. It was never a show. It's merely a communication.
Actually it is a communication.
That
He's taking it as a show cause. What have I said? Is reflected in the communication dated 26/9/2022 issued by the NHIDCL to the petition. The said letter dated 26/9/2022, according to the respondent, is a show cause notice. While the stand of the petitioner is that the said letter is not a show cause notice, but just a simple communication to clarify the issue of excess payment made to the contract. Suffice to say, subsequent to the above letter dated 26/9/2022, which was replied to by the petitioner by letter dated 3/10/2022. A reminder was sent by the NHIDCL on 21/10/2022 on the same subject matter, as reflected in the earlier letter, in the earlier communication dated 26/9/2022. The reminder dated 21/10/2022 was also replied to by the petitioner, giving reasons, replied to by the petitioner. I will not go into the nuances of those, what is there, it doesn't make any difference.
It's clear about
Suffice to say that there was an admission on the part of the petitioner that there was excess payment made to the contractor beyond actually executed work. Next step. Without going further into the merits of the issue as to whether the petitioner was at fault in recommending payment to the contractor for which the impugned debarment slash blacklisting order had been issued. comma. The first hurdle that would have to be crossed by the respondents is whether a show cause notice had been issued to the petitioner prior to issuance of the impugned debarment slash blacklisting order dated '23 1/20. In the case of Dash versus Dash, 19, in the case of MS Eurasian Equipment and Chemicals Limited, Supra. The Supreme Court has held that blacklisting involves civil consequences and that it has the effect of preventing a person from the privilege and advantage of entering into a lawful relationship with the government for the purposes of gain. The fact that a disability is created by the order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to represent his case before he is put on the blacklist. In the case of Gorkha Security Services,
Paragraph 16, 21 and 20.
The Supreme Court has held that. Law with regard to issuance of a show cause notice prior to blacklisting is firmly grounded and the giving of an opportunity to the person against whom action of blacklisting is sought to be taken and the giving of an opportunity of hearing to the person against whom action of blacklisting is sought to be taken has a valid and solid rationale behind it. It has held that it has held that the serving of the show cause notice is not only to make the noticee understand the precise case set up against him, which he has to meet, comma, but the other requirement is that he should be made to know the nature of action which is proposed to be taken against him. That should be stated in the notice, comma, so that the noticee is able to point out that the proposed action is not warranted in the given case, comma, even if the defaults slash breaches complained of are not satisfactorily explained. The Supreme Court further held in the above case as follows, inverted commas, when it comes to blacklisting, comma, this requirement becomes all the more imperative, comma, having regard to the fact that it is the harshest possible action. The Supreme Court thus held that in order to fulfill the requirements of the principles of natural justice, comma, a show cause notice should meet the following two requirements, viz. Number one and two, huh? Okay, at para 22 of the there. Okay, para 22. Next para. In the above case of Gorkha Security Services, comma, the Supreme Court further held that even if it is not specifically mentioned that the competent authority intended to impose such a penalty of blacklisting. Comma, but if it could be clearly inferred that such an action was proposed, comma, that would fulfill the requirement of the show cause notice. Full stop. However, a reading of the letter dated, a reading of the NHIDCL letters dated 26/9/22 and the reminder dated 21/10/22 does not give any indication that the respondent intended to impose a penalty of blacklisting / debarment of the petitioner from participating in future contracts with the NHIDCL / MORTH. Next. Just one more thing. Problem is the flow goes, no? After again, I'll have to read the entire file. I'll forget. Because after lunch again, I'll just finish it. I think you understand what's going on now.
Okay, liberty may be given to take any appropriate action.
That can be done. But you should remember that he has been debarred for now for 1 year, 4 months already.
No, that was state.
There's a stay.
It's only
Okay.
for 2 years.
Then there is, for all future time,
Correct. He'll have a black mark against his name. Na?
We'll follow the procedure.
Acha, one more thing you write, huh? After his statement, before I heard about, the council for the party submit that as on date, the excess amount paid to the contractor. It has been stated in the, it has been, no, you put it in Mr. PJ Factor, huh? With a, no, paragraph says, to a query put, to a specific query put to the council for the petitioner as to whether the excess amount paid to the contractor has been adjusted / reconciled. Comma.
It is not finalized.
Okay. The Mr. PJ Saikia submits that most of the excess amount has been adjusted, reconciled.
It is not finalized.
First of how,
because the contract was not completed, it was terminated for. because of that.
however,
The termination payment is there. That the
however,
They have-
it is not fully,
termination payment has not been made finalized.
however, the term, however, the same, the said amount has not been fully adjusted / reconciled. Okay, in as much as the MS Brahma, what MS
Manoranjan.
Manoranjan Brahma, the contract with MS Manoranjan Brahma has been terminated by the NHIDC. And the
Final adjustments,
final,
and the final adjustments, obviously will report.
yes,
I know it's the total amount of recovery from the motor firma is about 7 crore. Number finalized.
okay, that's a good, okay, this, and final adjustments would have to be made due to the termination of the contract. That's all. And then come back. In the case of UMC Technologies Private Limited, comma, the Supreme Court has held has held that specifically in the context of blacklisting of a person or an entity by the state or a state corporation, comma, the requirement of a valid, comma, particularized and unambiguous show cause notice is particularly crucial due to the severe consequences of blacklisting and the stigmatization that accrues to the person slash entity being blacklisted. It has further held that for a show cause notice to constitute the valid basis of a blacklisting order, comma, such notice must spell out clearly, comma, or its contents be such that it can be clearly inferred therefrom, comma, that there is intention on the part of the issuer of the notice to blacklist the noticee. Full stop. Such a clear notice is essential for ensuring that the person against whom the penalty of blacklisting is intended to be imposed, comma, has an adequate, comma, informed and meaningful opportunity to show cause against his possible blacklisting. In para 21. Next para. No. As can be seen, as can be culled out from the judgments of the Supreme Court stated above, it was imperative on the part of the NHIDCL to have made a mention that the petitioner could be blacklisted or that, full stop. However, no such mention was made with regard to the possibility of the petitioner being blacklisted in the letter dated issued by the NHIDCL. Full stop. Further, nothing can further a reading of the above letters shows that nothing can be inferred to the effect that there was a possibility of the petitioner being blacklisted slash debarred for 2 years. Next part. Then I'll reflect your judgment. So basically, I'll set aside. Liberty will be given. That's all. It is there in the Gupta also.
Liberty is always there.
Yes, everything. Item 1. Now we're going to start item 2 only. Two. Yes,
I'm engaged today, man.
you're engaged today. Where?
Today engaged I am.
You're engaged today. Where? You're here.
Yes, in this case, item number 3.
You're engaged. Yes. So, well, are you going to do this matter or what?
No, I took time.
You said you're engaged today. Engaged where? Elsewhere.
I got ES file is Wakalat number today.
Oh, say that. You said I'm engaged today. I said, okay, engaged where? What?
Earlier it was contacted by
Huh?
Earlier it was contacted by other guy.
What to do? Okay. Mr.
M.
M.
M. M for Mangalore.
Submits that he has been engaged today and will be filing Wakalatnama within.
But today I have time.
and submit that he has filed Wakalatnama today. He accordingly pays time to go through the brief. Mr.
P. Goswami,
P. Goswami appearing for the respondent,
2 and 5.
2 and 5 submit that he has got no objection to the prayer for adjournment. Leaves the matter
My lord, if there is no inconvenience in the month of June first week,
and leaves the matter. You give you a date. You want a date or no? No date.
fixed of
All right.
Saying on behalf of, Mr. PK for this consider for PK.
Is Mr.
PK for.
So?
He's not well.
He is not well.
The matter,
Okay, right. Adjournment
Take
prayer
up
has
for
been, huh?
2 weeks. After 2 weeks.
Okay, I heard Miss
and
Miss
Hadarika.
and Kalita
Hadarika.
appearing on behalf of Mr. BK Kaur. So he submits that, she submits that Mr. BK Kaur, learned counsel for the petitioner,
Petition.
is unwell. Accordingly, leaves this matter up to.
Accepted.
No one appears for the party. Leaves the matter after 2 weeks.
I think 6.
Maybe some blank paper. Yes, Mr. Daruka.
Met with a lot. Look, this matter relates to a uh, personal pay with regard to some employee of PRPL.
Oh,
PRPL, Bongaigaon Refinery and Petroleum Limited. So initially, the PRPL was an independent organization. Subsequently, it has been merged with IOC. After merging the IOC,
merge when?
that is in the year 2009. Now, after merging with the IOC, the salary pattern of the employees had to be changed. Now, what happened before merger, there was a grade of employees. They are called as special uh, selection grade employees, SSD,
Special grade employee.
special selection grade.
Yes.
They are just below the level of executive. Now the person concerned who were in this grade for a long spell of time, they were afforded with a special allowance. That is personal allowance, that is they call it personal. These allowance has nothing to do with their basic pay or dearness allowance. It is their personal allowance, and at the time of retirement, it will be counted for their gratuity. This much. And
How much is it?
995.
950.
And it,
950, it's a stagnation.
yes,
On the stagnation.
stagnation. 950,
This 950 is a stagnation allowance.
Yes.
stagnation.
So?
Thereafter, look, after the merger of PRPL with IOC, another pay structure was formulated. And by this pay structure, there was a promotional revenue were given. But this special allowance, though it was not initially abolished, but subsequently it was abolished.
Because promotional avenues came into effect.
No promotional revenue came into effect, but their pattern was changed. Pattern was changed that they will get something about it. No, your lordship may just go through the list of dates. That will give some idea. It starts from 1991.
Yes.
13 to 1991. A settlement was signed in presence of RCL Guwahati.
What is RLC?
RLC, Regional Labour Commission. Central Labour Commissioner, there is a Regional Labour Commissioner. There is called as RLC. And Chief Labour Commissioner is at Delhi.
RLC bracket C. What is C?
C is Central. RLC is Regional Labour Commissioner, Central. Between the management of PRPL and the union, by the state settlement, management agreed to a promotion policy, adopt a promotion policy for a period of 6 years. This is not very material. Look. Now, next settlement was held on 19/5/1995. A bipartite discussion was held with the union, and a new concept of promotion from non-executive to executive cadre was mooted by the management of PRP. This settlement provided reimbursement of local travel expenses, LTA, uniform reimbursement, and children education allowances to SSG grade employees equivalent to the lowest executive grade of employees of PRPL as a compensation. This facility was extended.
And for what? Why as compensation? Why? Because there was no promotional avenue for it.
Children education equal lower executive grade employees of PRPL as a compensation. The term of this condition of the settlement was made with effect from 1/8/1994 for a period of 10 years. Now this continues.
So that will end in 2004.
Then comes 1995. That was an inter office memorandum was issued from the implementation of the scheme of promotion under the state settlement, but it's not very important. Next comes to the 2024. A settlement between the management of PRPL and PRP Employees Union. The settlement was between the management and their union. In presence of RLC Guwahati in respect of promotional policy, SSG grade employees who were promoted to executive grade, are promoted to executive grade B, reimbursement of LTA for
What is LTE?
Local travel expense.
local travel expense. For car up to 70% as a rate as admissible to the executive grade B, and lump sum amount of rupees 550 per month as a compensation till promotion to the extent. The 550 was there. Therefore, it was announced. Now, this 550 was announced on 12/6/2004. Memorandum of settlement on promotion policy dated 25/7/24 was amended by another settlement, wherein the clause 2 of the settlement dated 25/7/2004, the earlier settlement, was modified. By this settlement, a frozen amount of rupees 950 per month was extended to the personal pay to the SSG to the grade employees till the promotion to the executive grade. So our case starts from this point. There is no problem. Now, what happened? This PRPL was merged with IOC. That was just merger took place on 25/3/2009. S12 Bongaigaon Refinery and Petrochemicals Limited was merged with the Indian Oil Corporation Limited. Now, after merger, what had happened? When on 29/7/2010, a long-term wage settlement was centrally signed with IOCL. That is now the management has been changed. It is now Indian Oil Corporation Limited for the employees, as all the refineries and other division in India, including BRPL, in order to bring uniformity along with the other union, other refineries, the settlement took place. Now, what is the problem starts here. A settlement on promotion policy on that year itself, a settlement on promotion policy was signed between the management of IOC Limited, Bongaigaon Refinery, and Bongaigaon Refinery Employees Union. That is the problem.
Your union name still remains Bongaigaon.
Okay. Oh, union name is same. Bongaigaon. No, it is still it's called as Bongaigaon Oil Refinery, but it is under Indian Oil Corporation. Initially, it was an independent organization. Subsequently, it was merged with the IOC. Because of this merger, this promotion policy pay scale structure has to be changed. And due to this change, some anomalies cropped up. And that anomalies have been exposed by the union for their activation. Whether these 950 amount which was given to them will be to them or not. That is the only question. Till their promotion. No,
So your case is whether the 950 rupees would continue to be extended to them in the absence of any promotion avenue. Is it?
yes,
That is the case.
that is the case.
Accordingly, the central government has referred the matter to the industrial tribunal to adjudicate by way of a reference. And that reference is under challenge report.
The reference was made to the industrial tribunal whether we are justified in claiming these things, and the government labor court, central government labor court, passed an award against that. And we have challenged that. This is the simple case. Now, look, a settlement on promotion policy was signed between the management of IOC Limited and the Bongaigaon Refinery Employees Union. Now, this settlement has created some problem. Tripartite settlement, 27/10/2010, a tripartite settlement was signed between the management of Indian Oil Corporation Limited, Bongaigaon Refinery, and the Bongaigaon Refinery Employees Union in presence of the Regional Commissioner Central on the issue of revision of pay scale, etc., related to the other allowance. That is with regard to pay scale. Okay. Now, what happens? This pay scale. After this pay scale, settlement for the pay scale, all scale of pay were revised. Now, but this was continued. This 950 rupees, which was granted to the.
Was this part of was this in the tripartite settlement? Was it there? This 950, was it mentioned?
No, it was not mentioned. It was not mentioned, but I will come to this. Yes, let us clarify it. That will be. Now, it will also come to their affidavit. That this will.
I know, let us go straight to the settlement. I think the two settlements
29/7/2010
And 27/10/2010.
29/7/2010 and 27/10/2010.
yes, sir. These two.
No, only one. 27/10/2010. No. This is the settlement.
So we don't.
29/7 is also important.
29/7.
And because they are also the signatories.
29/7.
Yes.
Yes.
Clause
Yes, sir.
2.5.
Yes, that is correct. He is correct. In this settlement, this union is also a part of the settlement.
Was this 950 mentioned there?
No, this 950 was not mentioned. Only one thing, that is the bone of contention is there.
So in both 29.7 and 27.10, this 950 was not mentioned in neither of them.
To bring them as par of the salaries of the IOCL.
Actually, pay scale was different.
Your pay scale was less over earlier or more. It was less.
It was less for. I am not very sure of it. No, that's all right, no problem. That is, the pay scale was revised.
No, pay scale earlier, you see, so after merger, the Bongaigaon, the refinery employees union, that is not the only union that was there at the time of merger. There must have been other unions also. So the Bongaigaon refinery union were there enjoying a lesser pay scale than the IOCL union.
For my knowledge, though I am not sure, but it was less.
They were less.
They were less. Accordingly, they were given one increment more to bring them at par. They employed the
That is not very clear, but one increment was given.
Okay.
Scale of it.
So their increment starts in the month of July, IOCL increment starts in the month of January. So accordingly, they were given that increment
More or
in the
less
month
same.
of July. Thereafter, again, it will start from January.
To bring the parity of the increment. Now, Lord, let us come, though the settlement is not annexed yet. But my friend has filed an affidavit. I am relying on their affidavit. I will not come. What they have stated.
LCR is.
Healthcare is
The cost 2.5 of both these aspects. That's it. That you will get it.
Clause 2. Clause 2, 2.4. Here it is in clause 2, settlement dated 25/7/2004. So, clause 2.4, 29/7. I am reading that clause here. Look at this. This settlement will supersede. The only limited feature. This settlement will supersede the agreement related to any other pay related benefits arrived between the recognized union of the S12 BRPL and its management in respect of the workmen BPL. So we have to construe these clauses from whether these
Where are you reading? Which page are you reading?
they are affidavit.
Their affidavit, which para?
Page number 11. Page number 11, last but one paragraph, the last portion.
Then, so that settlement, that the 2.4 of the settlement. Now that is not in your favor.
According to them, that is not in my favor.
According to you, it is in your favor.
According to me, it will not affect so far the personal payment is concerned. Personal pay, because the settlement will supersede the agreement related to any other pay related benefit. Whether this personal pay was the pay related benefits or not.
You see, arrived between the recognized union of the erstwhile BRPL and its management in respect of workmen of BTI. So this 950 was given to you on the basis of what?
Technically.
Huh?
Technically.
By whom?
By the management of BRPL.
On the basis of what? On the basis of a settlement.
Yes.
On the basis of a settlement dated 6/12/2004.
Yes.
So that this 2.4, it appears to cover that settlement made between you and the UN, not no. You and the PRPL.
Oh, that's
Because
all
it
right.
says here, this settlement will supersede the agreement related to any other pay-related benefits arise between the recognized union of the erstwhile BRPL and its management in respect of workmen of BGL.
Now, the pay-related benefit means basic earnest allowances and other allowances. It is a personal allowance. So for 950 is concerned, it is only confined to some persons who are working in BRPL and suffering from sick. And their salary, this 950 will not be marked with the basic pay or anything else. It will be continued till their retirement. And at the time of retirement, this 950 will be counted for the
You see, the issue is when the IOCL merged with the BRPL, what were the terms and conditions of the merger agreement? What did it say anything with regard to the personal pay?
no, they have not. So for the personal pay is concerned, look,
In 40 agreements, that clause number 2.4. It supersedes all the earlier agreements.
yes.
That's what, it supersedes all the
And they
other.
were the signatories and
No, so far the thing, it depends upon the interpretation. It depends upon the interpretation. Look, so far pay-related benefit is concerned. What is the pay-related benefit? Pay-related benefit means the benefit which is extended to all others persons. And it is a personal payment to these employees also. Whether these personal pay will be counted as a pay-related benefit from it. And so far,
Let us see this 6/12/2004 memorandum of settlement. 6/12/2004.
you know,
Because by this 6/12/2004, this 950 was given as personal pay
yes, sir,
that was an agreement between,
till promotion.
field property.
that was an agreement between the BRPL and the union,
Anyway,
not with I.
that's all, no problem.
And what was the
mentioned in the 6/12/2004?
6/12/2004? And I also want the agreement made between the BRPL and the IOCL at the time of merger.
No, no, sir. May I read our application process?
Yes.
Everything will be clear.
Yes.
Prepare it. That is what we will cover.
Sure, no problem. Six, actually, no problem. I have to go, carry on. Yes, 27, carry on.
Lordship may kindly come to paragraph number 2, starts from paragraph number 2 at page 3.
Yeah.
The whole picture will be clear, Lord. That before dealing, as your Lordship got it, that before dealing with the averments made in the writ petition, your deponent would like to place the following facts before the Honorable Court. That the Government of India Ministry of Labour have referred the following issues to Central Government Industrial Tribunal come Labour Court at Guwahati for adjudication, whether the action of the management of Messrs IOCL Bongaigaon Refinery in discontinuance of the payment of frozen amount personal pay of rupees 950 per month in terms of the tripartite settlement dated 29/7/2010 is justified. If not, what relief the grade 8 earlier SSG employees are entitled. In terms of the promotion policy for workmen of erstwhile Bongaigaon Refinery Petrochemical Limited, in short BRPL, effective from July 2004, workmen working in SSG with 6 years service in SSG grade beginning from 31/7/2004 were entitled to personal pay of rupees 950 per month as technician benefit. BRPL was merged with Indian Oil Corporation Limited effective from 25/3/2009.
After merger, BRPL became a unit of IOCL and known as Indian Oil Corporation Limited, Bongaigaon Refinery, and all workmen of Rajdoil BRPL became workmen of IOCL Bongaigaon Refinery. A tripartite settlement was signed on 2/4/2009 between the management of IOCL Bongaigaon Refinery and the Bongaigaon Refinery Employees Union on work-related allowances, perquisites, benefits, etc., revising all such benefits exactly as per IOCL. The said settlement also includes a clause to the effect that erstwhile BRPL rules on leave, LTC, holiday, working hours, medical, loan and advances, TA rules, etc. will be replaced with IOCL rules. It is pertinent to mention herein that the president of the petitioner union was a signatory to the said settlement. Then Lordship, the management of IOCL at corporate level signed a long-term settlement on wage revision for workmen with all recognized unions of IOCL, including the present union, on 29/7/2010. Based on the said MOS, a tripartite settlement was signed between the management of Bongaigaon Refinery IOCL and BGREU, that is the union, at unit level on 27/10/2010 in presence of the RLC, Regional Labour Commissioner, Central Guwahati. The settlement signed on wage revision is common for all refinery units of IOCL except the extent that BGR workmen, the settlement was effective from 1/7/2007, and for all others, the settlement was effective from 1/1/2007. This increment just now I have placed before your lordship that their increment starts in the month of July BRPL. That is why they were given from July, and thereafter it continued from January, and this increment, one increment they are getting more than the IOCL. The president and the petitioner union were the signatory of both these agreements, Lordship. Immediately after signing of the LTS, that long-term settlement dated 29/7/2010 on wage revision, a tripartite settlement on revised promotion policy was signed between the management of Bongaigaon Refinery and Bongaigaon Refinery Employees Union on 16/9/2010 before the Assistant Labour Commissioner, Central Guwahati. In the said revised promotion policy dated 16/9/2010, the provision regarding the frozen personal pay of Rs. 950 per month to SSG workmen completing 6 years services was not included, unlike pre-revised promotions policy settlement. Clause 3 of the new promotion policy contains the following clause. Pending finalization of modalities for movement from grade 8 to grade 9, workmen in salary grade 8 who do not get promotion to officer grade A upon completion of 6 years in the grade shall be given an additional increment at the rate of last increment drawn as personal pay, provided he has minimum satisfactory ACR relating to rating in the preceding 3 years, which will be treated as basic pay for all purposes. This benefit, however, will be admissible till the workman is promoted to grade A officer. Such eligible workmen who do not get promotion to officer grade A upon completion of another 4-year services as per stagnation benefit as above shall be granted one additional increment at the rate of last increment drawn as additional personal pay, which will be treated as basic pay for all purposes. This benefit will be admissible till the workman promoted to grade A officer. The benefit of additional personal pay shall be performance linked and shall be given to such workmen who have minimum 2 outstanding years in grade 8 in the preceding 4 years.
Just a minute. This clause 3 stagnation in grade 8.
Lord.
This is part of the settlement. Is it?
Yes.
Settlement dated?
Lord. There is a note, Lordship. Besides the above, no other stagnation benefit shall be permissible to be admissible to workmen in grade 8. Thereafter, Lordship, the further in terms of clause 2(4) of the tripartite settlement dated 29/7/2010, all agreements relating to any other pay-related benefits earlier arrived between the recognized unions of the erstwhile BRPL and its management in respect of workmen of BGR stand suspended. Thereafter, Lordship, after signing of the superseded. After signing of the above tripartite settlement on 29/7/2010, promotion policy settlement signed on 16/9/2010, and earlier settlement on perquisites, allowances, etc., signed on 2/4/2009, all pay-related benefits and perquisites allowances of busier workmen have
Yes,
fully become.
you see, this 2.4 appears to hit your case.
Yes.
It appears to hit your case. It directly hits your case.
And
2.4. Have you made a challenge to 2.4? But they were part of the agreement. Then,
How can I tell?
then, then,
This is that. Oh, but, I, but, I,
but that is exactly what has been stated in this 2.4. That is exactly the point. It says here that page
Page 6, clause Z.
it says here all agreements related to any other pay related benefit arrived earlier between the recognized unions of the erstwhile PRPF and its management. So you are the union of the erstwhile BRPL and its management. That means the management of the BRPL. In respect of workmen of BGR, stands supersede. So this directly you have signed your own death warrant.
but I, but the more statement, it, not that it,
Pay related benefit.
it, benefit. Alright. Yes, that is well, here.
Uh.
And it, the effect of the work, it is that the is I, they paid it,
Whether it's a pay related benefit.
that is the only thing. Because it's a critical. It was ended to the categories of employees were very complicated. And these 960 will not be counted for the basic or it has no relevance whatsoever with the other scale of other participants. It will only be considered at the time of retirement or the purpose of completing the act. Whether these 960
Okay, what do you understand by the word pay related benefit? What would it give me an example of pay related benefit?
pay is the basic thing, the basic pay. And it's around. These are the basic pay is the basic. But the other is special pay. Personal, but the personal pay was kind. Who is suffering something. Either the paying is the what is 5 kilo. And what is 5 days. What is 5 years. But after giving this related benefit, the management has considered not the Indian state. But yes, it are waiting for their. So, Indian context is that these related benefits will be there, long they do not take. any
The stagnation benefit is also taken into consideration in clause 3.
Yes.
Clause 3, that page number 5, F.
benefit.
এই settlement-এর কথা বলি। Page 5 of my affidavit.
Yes, yes.
Immediately after signing of the long-term settlement dated 29/7/2010 on wage revision, A tripartite settlement on revised promotion policy was signed between the management of Bongaigaon Refinery and Bongaigaon Refinery Employees Union on 16/9/2010. 16/9/2010 before Eastern Labour Commissioner, Central Guwahati. In the said revised promotion policy dated 16/9/2010, the provision regarding frozen personal pay of rupees 950 per month to SSG workmen completing 6-year services was not included, unlike pre-revised promotion policy settlement. Clause 3 of the new promotion policy contains the following clause. Pending finalization of modalities for movement from grade 8 to grade 9, workmen in salary grade 8 who do not get promotion to officer grade A upon completion of 6 years in the grade shall be given an additional increment at the rate of last increment drawn as personal pay, provided he has minimum satisfactory ACR rating in the preceding 3 years, which will be treated as basic pay for all purposes. This benefit, however, will be admissible till the workman is promoted to grade A officer. Such eligible workmen who do not get promotion to officer grade A upon completion of another 4 year service in grade 8 from the date of grant of personal pay as stagnation benefit as above shall be granted one additional increment at the rate of last increment drawn as additional personal pay, which will be treated as basic pay for all purposes. This benefit will be admissible till the workman promoted to grade A officer. The benefit of additional personal pay shall be performance linked and shall be given to such workmen who have minimum 2 outstanding year in grade 8 in the preceding 4 years. Note, besides the above, no other stagnation benefit shall be permissible to the admissible to workmen in grade 8. They are the signatories to this agreement. Then in clause 2.4, all other agreements is superseded by the present agreement. And they are getting what is they are getting, Lordship will get it at page 8. Page 8, clause 1. That is what it was. In the earlier system of BRPL, annual increment otherwise used to be admissible from 1st of July of the year. However, with the view to have a common system in entire IOCL, BGR workmen have been extended the benefit of preponement of the annual increment by 6 months. As per settlement after drawal of the first annual increment in the revised scale in July 2007, the next annual increment has been allowed to be drawn at full rate from 1st of January 2008. This benefit of early drawal of increment by 6 months every year is a benefit that will remain in force on perpetual basis. This by itself amounts to an extra pay benefit of rupees 12,000 per annual approximately. Under normal situation, the DA for BGR workmen would have started from 0% on 1st of July 2007. However, because of the merger with IOCL and signing of common settlement, the BGR workmen have been allowed DA of 1.3% from 1st of July 2007, taking base DA neutralization point of 1st January 2007. This additional benefit will be perpetual and keep going. This has reached up to 2.1% additional DA benefit as on 1st of July 2012, which has become additional pay benefit of rupees 850 per month approximately. And may I place the evidence of their workman witness? That is, your lordship will get it at page 48 of the writ petition.
Yeah.
The next paragraph, lordship. In course of his cross-examination, as your lordship got it, page 48.
Yes, yes.
In course of his cross-examination, the workman witness number 1, Sri Mahesh Ishwari, stated that he had mentioned in his evidence on affidavit at para 3 that in view of the tripartite settlement dated 13/2/1991, the employees were allowed reimbursement of local travel expenses, uniform reimbursement and children education allowances, but it was not mentioned in the tripartite settlement dated 13/2/1991, marked as Exhibit 2. And that in para 4 of his evidence on affidavit, he stated that as per bipartite settlement dated 24/7/1995, frozen amount to the tune of rupees 950 only was extended to in the bipartite settlement dated 24/7/1995, but there is no mention of extension of frozen amount. In their Earlier lordship, it was there in the BRPL, the agreement with BRPL dated dated lordship,
2004.
yes, lordship. Thereafter, but it was also not mentioned. He also said that there is no mention in the tripartite settlement dated 25/7/2004 that the frozen amount has been renamed as personnel pay and the mention of frozen amount of rupees 950 is not there. He also said that as per clause 2 of the tripartite settlement dated 25/7/2004 has been superseded by clause 2.1 of the tripartite settlement dated 6/12/2004. These agreements were with BRPL lordship prior to 2009 merger with IOCL, and that the frozen amount of rupees 950 as personal pay has been introduced for the first time in tripartite settlement dated 6/12/2004. But after merger of BRPL with IOCL, one long-term settlement dated 29/7/2010 was arrived at between the management of IOCL and their union, wherein the BGREU
I
was
don't have that part.
also-
Okay, yes, one long-term settlement dated was arrived at between management.
This settlement will supersede 2.4. Those were mentioned. He has himself mentioned, lordship, and they were the signatories there, lordship.
No, that is all right, but what about the 950? What has been said?
950, that clause 3 of 29/7/2010, it goes, lordship. Thereafter 2.4, all earlier settlements were superseded. Had it been the case of the union that they were not a party there, behind their back these agreements were signed, then matter would have been a little bit different. But
And please come to page 49, the middle portion. From the right side, he again stated that the management of IOCL wrote a letter dated so marked as Exhibit 11 to the General Secretary BGREU, stating that the frozen amount of so as personal pay being drawn by the workmen under the erstwhile BRPL will no longer be payable, and it will be discontinued with effect from August 2010.
lordship.
After signing of the long-term settlement dated 29/7/2000. He again stated.
Okay, later. It is later issued by the management. That is, he has brought up the dispute. Actually, after this settlement, this present amount was paid. Although not starting sale, paid later, it is state, target exhibit. The general secretary by stating that there is a amount of 950 as personal pay being drawn by the person under the BRPL will no longer will be payable as no longer will be. No longer
Yes,
will be
lordship, we have-
payable, and it will be disputed the effect of person. It has dropped up the.
Because lordship, it was
Settlement. After that settlement, it is a problem. They were of the view. Because here, it's okay. What I mentioned is only case whether this original amount is okay or not. Because what are what mentioned.
Just a minute,
Not at all.
just a minute,
It
just a minute. Page 48,
is
internal page 8, yes. Which line? Second line. WW1.
They said that it is that's called radiated stuff. And this, and this, have been radiated payment has got not the period of the but it is longer chart settlement arrived on defined location. Hence, that is considered to get of things and are not IT management to be declared a thing.
This is in C plot, thereafter in cross, I have taken it off.
That is the according to them, it is about radiated. And according to the initial, this radiated basis is the.
How do they calculate this 950 on the basis of what? Pay scale?
No.
What? How did it come about?
Typically, the 20% of their prevailing around, as averaged by the. That was the time it was considered as a bit.
What do you understand by the word pay related? Allow.
Because of the stagnation, that amount was given to them. And accordingly, Lordship, on 29/7/2010 agreement, it was dealt to it. It was dealt to it in clause 3. And they were given that not that 950, but it was substituted by some another benefit, which we have specifically mentioned in our affidavit. In clause 3, that page 5, and this in page 4, it was specifically
Yes, this
besides
clause
the
3
above.
This clause 3 says no other stagnation benefit will be permissible to be admissible to workmen in grade 8. Page 6 of the affidavit of. Yes.
Addition in grade three,
Yes, come to the bottom at page 6 note.
besides the above, two other technical benefits shall be permissible, be specific to government in grade 8. Besides the other, uh, besides other, above, two other technical benefits shall be permissible, be specific to the government in grade 8. The first benefit was from grade. That will be clear from the technical bit.
No, this personal pay is a stagnation benefit because you have got no promotion avenue. Yes, apparently. Now there's another, but just prior to that note, this is benefit of additional personal pay shall be performance linked. Now, additional personal pay will be performance linked and it will not be due to stagnation. That's what it shows. Then, so
It's not that you technique. It's to perform. To read it, so they.
No, yeah,
no.
Painting,
No. You see, when you read this clause C, it basically appears to show
painting, finalization of the model for students from grade 8, grade 9. Part-time in salary grade 8. But if
basis.
you do not get promotion to officer grade A upon A, officer grade A, upon completion of 6 years, in the grade shall be given an additional benefit at the rate of half of payment drawn by the personal, drawn as personal, provided, there is a provision. Provided that there as minimum, eligibility
satisfactory.
satisfactory NPS regarding
Rating.
the relating rating in the preceding 3 years. It will be treated as a benefit for all purposes. This benefit, however, it person Here, dictation date, look, that's hard. Because of the highway of the. And the earlier benefit was not yet. It was not. 50% who had suffered from or exactly.
This does not seem to be in your favor. Because they are saying that persons who do not get promoted shall be given an additional increment.
By the
Minimum satisfactory ACR so you have got to have.
earlier
Then otherwise, if you do not get a person who is below average, why should he get? Because why should a person who is not deserving get increment? That is correct. He should be, only those who are deserving should get increment. Because a person who is below is whose ACR is not satisfactory can never be promoted. You see, you have to have a normal ACR to be promoted. If you have got a below average ACR, there's no question of you being promoted. Because
This settlement is also not under challenge.
this settlement is not under challenge. But this settlement, it appears that you have shot yourself in the foot. This settlement is dated?
This is 16/9/2010.
No.
No, 29/7/2010. Your Lordship may kindly page 5, clause F. Immediately after signing of the LPS dated 29/7/2010 on West Revision, a tripartite settlement on revised promotion policy was signed between the management of Bongaigaon Refinery and
Where are you reading? Where are you reading?
page 5, Lordship, of my affidavit.
Let us see the settlement.
Yes.
Because you see, your settlement talks of 16/9/2010. Then it talks of 29/7/2010.
If your Lordship
So,
comes to page 5 of our affidavit,
Ah.
it will be clear. Thereafter, I will page the settlement.
No, tell me the date. Date of the
This
settlement.
clause 3 is from 16/9/2010.
9/2010. You see, so this settlement, this clause 3 is from 16/9/2010. Is it?
Yes.
It was signed on 16/9/2010.
Yes.
It was signed on 16/9/2010. If it is that, then come to page 7. Para J. It talks of 28/9 October 2010. Now, is this paragraph J a part of the 16/9/2010?
Lordship, let me go.
It's like me writing a letter today and I'm talking about
Yes.
things that happened to me day after tomorrow. How can it be?
No, Lordship. This payment of revised pay scale
Let
including
me see the settlement. This one. 16/9/2010. Yes.
the clause 3.
What is this F that they're talking about? J. There's no J out here. You're mixed up. Your affidavit is all mixed up.
No, Lordship. J is a letter. The payment of revised pay scale including arrear payments was implemented on 29 of October.
You see, you have made all this a part of which number? I don't know. Made a part of 2. You have to make the settlement of 69 separate paragraph, then the other separate paragraph. You have joined everything up. That's what confusing.
clause 3 of settlement dated 16/9/2010.
Then where is this 2.4? 2.4 is part of which? That is another, that is part of 29/7/2010.
Yes, Lordship. In 16/9 also, Lordship, 16/9/2010 also there is 2.4.
Where?
I have that horizontal fact.
No, I'm not on that. I have the settlement in front of me. That is causing confusion.
2.4 is also there.
There is no 2.4 here. Show me, you see, I've got this, that is what is confusing me. Your affidavit is all one big kitchery. Everything is mixed up. This is the settlement which Mr. Das Gupta has given.
That 2.4. 2.4
No, you look at this settlement.
on 16/9, there is no such 2.4.
That is what I'm asking you. Where is that 2.4? You said though it is there.
2.4 is on the settlement dated 29/7/2010,
That is
and-
and
and thereafter, Lordship, another agreement that is dated.
your affidavit is mixed up here and there. You have put
Lordship, I
that.
have narrated this because of the story, Lordship.
29/7/2010.
I'll just tell you, your paragraph 2F starts with this 29/7/2010,
Yes.
and your paragraph
No, in
2G starts with 2.4 of 29/7/2010. However, in your paragraph F, you have talked about clause 3, which is of 16/9/2010,
yes, there is another.
and you have not
because
put the date also. It's very confusing.
No, Lordship, after 29/7/2010 on wage revision, this agreement came because of that wage revision.
I know, now only I have realized. Your affidavit is confusing. This is what has caused the confusion. This is 16/9/2010. Where is that? I think so. 27/10/2010. Where is the 29/7/2010? 29/7. Where is that?
27/10 or 29/10?
29/7.
Hold on. I'm giving. 29/7. Yes, I'm giving.
Yeah, paragraph is very confusing.
Yeah, I'm.
No, not you. I'm talking about the government.
Twenty-nine/7 or 27. 2.4 of 29/7.
Problem is, I don't know which date. This is 29/7.
Yes.
This is 29.
29/7, 2.4 clause. And that 16/9, Lordship, that
Now, where is the award? Page 41. Let me
Yes.
see what is the reasoning given.
The long award.
Very good. Is there any other hearing? Huh? Yeah, item is what regarding? Huh? Regarding what? Service matter, contract matter, what?
Same method, like, so. And that is our, already we have, complied. We told, service line.
Then what do you mean?
Okay, in spite of that, propose to this time and again. The review of the, that we are now we put it on.
Nothing we have that the central government has done their private evidence. They are only taking time for their search. Okay. Only 5 minutes. Take only 5 minutes. For this.
We are hit the award, but defines is whether the action of the management of Mrs. IOCL Bongaigaon Refinery is in discontinuance of the payment of frozen amount, personal pay of rupees 950 per month in terms of the tripartite settlement dated 29/7/10, clause 2.4 is that. This is only. We need not go for any other because the evidence will not change the terms of the settlement. It is up to your lordship secretary, depends on it. There is a clause to quote 29
The problem was I was going in a certain way. Now, your affidavit is all mixed up. You know, it's not clear. No, that's the problem. That's what was confusing me. I was getting it, but it was not making sense. It,
I will give a compilation plan, but you can't see. Tomorrow, day after tomorrow. Because unnecessary reading of this long settlement, Lord, because it only depends upon the interpretation.
no, I need the settlement because
That's all that.
I
Only
need the
this
settlement because this affidavit is not helping. It's confusing me. That's it. And I need the settlement. Because, this makes it easier to understand.
This key settlement.
I thought the affidavit was going to help, but it mixes up everything.
2004 settlement is required.
What is required is
These three settlements.
29/7 6/12/2004,
6/12/2004, yes.
29/7
2008.
16/9/2010,
Yes.
27/10/10. These 4 settlements are required. I have got 169. What is this? This is 27,
29/7.
29/7. I don't have 27/10.
27/10, yes, I am giving. It is 27.
And 6/12.
6/12, 6/12/2004.
29.
Only 6/12/2004, no. Yes, that is with me.
9.
Should I give it to you?
What is this? I think this they have already given. This is only 27. 2710, there are two of them over. 29.7. 29.7.
Hmm, 6/12/2004 is with me.
About 27. Yeah, 27. 10, 10, 10, 16, 9. 16, 9, 26, 16,
16/9/2000.
16. No, this is 6. I don't listen. This new chapter confusing. Out here in this 29,710, there is stagnation incremental. think we'll have one more hearing. We'll have to go through. Right. Then we started again after a week. You can make a photocopy of this.
Oh, I shall supply to you. You have the video of the book, correct?
Yeah.
Very recent.
Okay, yes, sometime next month.
16. Happy you know. Well, this matter relates to the focus notice issued to the NFRA by Assistant Labour Commissioner Central of Portugal. With the direction that for focus for non-compliance of their judgment. But I take the lordship page 18.
Who's for the other side?
They are not appearing that the system.
He was.
My signature. Okay.
According to them, the you are for the railways.
Yes, you both. He is appearing it, I don't know, eight.
You see, the thing is that notice was issued for non-compliance of the award. Now, they have said that the award has been finalized. I mean, has been complied with. But why didn't you go to the tribunal and say that?
We have given reply. Focus.
And what are they? And what are the?
Even then they are sending notice. Whether it is under the purview of the union. These people have retired long ago from service.
You are for whom? You are for the Union of India. Who is appearing for response number 2?
Yes, that is a labor contract.
No, this is the General Secretary, Rail Mazdoor Union.
Yes. And these laborers, they are never coming to the court.
Yes,
Saha is a performer response number 2.
let him come, let him say.
He has filed the affidavit, he has never come to the court.
He has filed affidavit.
Yes,
And saying what?
my letter I have seen, madam. I have, he has given a copy. I think it is filed in the court of.
Joint General Secretary of Rail Mazdoor Union.
Yes, yes. Yes. Okay, put it to poor benefit. Yes, yes.
What is the award passed by the labor court?
My lord, I take your lordship, page 18 can. To give the benefit of group D person, my lord, to the upgradation that we have done. We have given the benefit of the monetary benefit also. Page number 24, para 20 is the operation for cooperative person.
This union is standing for whom? For two persons, huh?
Yeah.
For Deepak Bhattacharjee and S.R. Bhaumik only.
Bhaumik, they are the our railway employees.
And both of them have to be appointed to grade 1 post, grade 2 and grade 1.
Grade 1, grade 2 from they are working as in the mechanical department, so we have to give them some promotion. So with the compliance of the order.
Where is the promotion order?
Kindly page 24, para 20 can see. What was the award given in that paper?
Where is the promotion order?
I am showing my lord.
February 25.
Kindly come to page 1 and accept 2 my lord. 2 and 3, both are there. In terms of the railway board letter number such and such, Bhattacharjee, grade number 2, the pay scale such and such. And
And what about Bhaumik?
Post of oil and Bhaumik. Bhaumik is next page. In terms of railway board letter such and such and such, grade 3 to grade 3. 2. Yes. As oil and with effect from 1/1/11.
Can we have this person here? Who is this person for the respond number 2?
That's not to be union, man.
Yes, Saha.
Yes.
Where is he?
He never comes to the court.
This is non-compliance with how many awards? How? 1 award or 2 awards?
Only one award for 40%. And these persons have already retired from service. And they have got probably they have never approached the railway authority for there any grievance they have got.
But what about this order dated 28/1/2021? It talks of 2 awards.
Well, please, can you take trouble to come page 28 minutes? What is the given to us?
Yes.
This is difference to the office letter number such and such dated 28/12/2005, sent by registered post. In this connection, it is stated that although the reasonable time has been elapsed, no reply of the implementation of the report has been received in this office. Then, my lord, we have given an Annexure 5, your lordship will find, again show cause notice, then your lordship will find page 31.
Yeah.
Our reply is that it has been complied with. Implementation of Industrial Tribunal Award number 11 of 2004. Reference to the ALC number 25/8 , 2010.
But what about page 34?
Page 34. This is notice show cause again. That is the input we have from. Lastly, and we have replied 35 page, 35. Show cause notice, non-implemented.
Yes, madam, where is your thing? Yes. Okay, right. Heard Mr. S.C. Biswa. We'll wait for her. In the meantime, I'll start dictating. Heard Mr. S.C. Biswa. Learned counsel for the petitioner. Also heard Miss. Huh? No, you're senior. Hey, guy. Learned CGC. Appearing for point number 1. Yeah. So no one appears for point number 2. Even though Mr. A. Saha had appeared for the point number 2. And the petitioner is aggrieved with the issuance of notice dated 9/11/2015 from the Office of the Assistant Labor Commissioner, bracket C, Guwahati. The said notice pertains to non-compliance of the award dated 25/2/2005, passed in reference case number 11 bracket C of 2004. According to the petitioner, the said award has been complied with way back in 2007, and the two workmen concerned have also retired from service. He accordingly submits that the impugned notice should be certified. And the yes, to be satisfied. Then we leave a blank, huh? Then you write. I have heard the learned counsel for the part. The award dated 25/2/2015, passed by the CGIT cum Labor Court Guwahati in reference case number 11 of 2004, pertains to the management of NF Railway, Maligaon versus the Rail Mazdoor Union, which has espoused the cause of the workmen Shri Deepak Bhattacharjee and Shri S.R. Bhaumik. Page 18. The industrial dispute, which has been referred to the CGIT cum Labor Court, is to be decided by the Labor Court, is as follows. Inverted comma, whether the action of the management of NF Railway, is denying upgradation to scale of grade 1 in respect of Shri Deepak Bhattacharjee and Shri S.R. Bhaumik welder is justified. If not, what relief Shri Bhattacharjee and Bhaumik are entitled. Full stop. Next paragraph. This is in page 18, all of them. Yes. Then the learned CGIT cum Labor Court disposed of reference case number 11 of 2004, by award dated 25/2/2005, by holding that it was the responsibility of the management to move the railway board for sanction or creation of upgradation benefits posts with scale for the post of grade 2 and grade 1 with economic benefit to give upgradation benefit to the workmen concerned. It further held that according to the referred schedule or issue to be decided, it further held that the issue was decided against the management and in favor of the workmen. And as such, the workmen were entitled to have upgradation benefit or posting to grade 1, to grade 2 and grade 1, to grade 1 and grade 2. Next part. Where is that promotion order?
Page 25 and 25, 20, and 26, both you will get.
The Mr. S.C. Biswas, the learned counsel for the railways, for the petitioner, has taken this court to the
Office order dated
office order
number 8 of
number 8 of 2007, dated 13/2/2007. Wait, office order dated 8 and 34.
Yes.
8 of 2007 and 34 of 2007. Issued by the Assistant Division Engineer / MSG for Senior Divisional Engineer / MSG. This is at page 25 and 26, which states that, which shows that, dated 13/2/2007 and 9/4/2007 respectively, which shows that Shri Deepak Bhattacharjee, welder grade 2, has been promoted to the post of welder grade 1. And Shri Supriya Ranjan Bhaumik, welder grade 3, has been promoted to the post of welder grade 2. Next. On considering the office orders, order number 8 of 2007 and 34 of 2007, which shows that the two workmen have been promoted to grade 1 and grade 2 posts. This court finds that the award dated 25/2/2005, passed in reference case number 11 of 2004 by the CGIT cum Labor Court Party, has been complied with. Full stop. The ESDT office order number 8 of 2007 and 34 of 2007 are reproduced below as follows. Page 25 and 26. Okay. In view of the above, there is no justification. There appears to be there in the review of the above, there does not appear to be any justification for issuance of the show cause notice dated 9/11/2015 for non-implementation of the award of the CGIT come labor court in reference case number 11 of 2004. The impugned show cause notice dated 9/11/2015 is accordingly set aside. The writ petition is accordingly disposed. Acha, and you? Huh? Similar. Acha, what is your name? DKD. Oh, one at a time. Both the case cannot be. You all are both, unless you all are both, one is senior, one is junior, cannot be. You cannot make up the procedure as you want. Uh, and what about this case? Out here, the reference case will be different. Huh? Reference case is different. Both the cases, you are there. Mr. Biswas is not there actually. Both of you are there. So in this case, you will put your name. It will be one set of fees, but you get two set of fees. Huh? He'll get two fees. And you'll get one, and you'll get two also. Why should he get two? By whom? Okay. You put SC Biswas and so in that earlier one. And out here only his name. Okay. So out here, right, heard Mr. So learned counsel for the petitioner and Ms. A. Gayan, learned counsel for the uh, respondent. Oh, what? Point number one. This point number one. No one appears for the point number two. Sir. The petitioner has paid for setting aside the show cause notice dated 9/11/2015 issued by the where is that? Show cause notice dated 9/11/2015 issued by the CGIT Town Assistant Labor Commissioner Center from Guwahati for non-implementation of the award number. Where's the award? Non-implementation of award dated 22/1/2002. 22/1/2002. Passed in reference case number 5 bracket C of 2001. There are page 14. Huh? The industrial dispute which was referred to the industrial tribunal. This is not CGIT. This is industrial tribunal. The CGIT it referred to the CGIT come labor court. Labor court was on the following issue. Page 14, huh? Last paragraph. Whether the action fell so. Good stuff. Reference case number 5 bracket C of 2001 was disposed of by award dated 22/1/2002. by holding that. Who is the workman out here? Huh? What? Yeah. Tell that the principle of equal pay for equal work was applicable for all. And accordingly, the railway board was to consider the grievances of the workmen and to dispose the reference made by the railway administration Maligaon within 6 months from the date of the award. So, the workman was thereafter to be given the restructuring benefit and paid the same pay scale and paid the pay scale with promotional benefit. It is as with promotional benefit as per the they should be paid the same pay scale, including any promotional benefit that they may be eligible for. Where is the order complying? Huh? No, no. We'll list this after some time, right? What have I said? To stop. Uh, the next paragraph, the petition council submits that the award passed by the learned CGIT, some labor court has been complied with. This as no one appears. No, no, this is the matter again. After 2 weeks. There's nothing clear with it. There's not. I don't see where you have complied with the order. No, we will see on that day. We'll see on it. No point. Item. What is this matter about?
They have challenged an order of the appellate authority, section 127.
Huh?
They have challenged an order of the appellate authority under section 127 of the DPR. They result in
So what to do? Not here. What is to be done then? Just have to see whether the procedure has been complied with. So has the procedure been complied with? You have got no clue of why you're standing there. What to do? Right. It is submitted that Mr. G. N. Sahiwala, along with senior counsel for the petitioner, is on legs in another court. Mr. K. P. Pathak appears for the APDCL. This is the matter. It's- No point. This is the matter after 2 weeks. Then what is this matter about? Huh? Filed by the labor court. Who is for the other side? Who's for the respondent? What to do? Can we dispose of in their absence? Can you call them? Time is also quite less. Okay, right. As no one appears for the respondent, this is the matter after 2 weeks. You are the owner of the land.
The back force of level. I for the. Town. So I advise them for letting to allow me to send that my first country. And I was and I was to such a
Boundary.
external wall.
Boundary wall. No, room.
Going.
Page.
That's okay. That's correct.
Yes. Okay. By the municipality. Dumduma Town Committee. Then open space.
For it was excellent corridor,
Okay.
but the corridor was not full. Therefore, I think to start still now. We have already accepted their
Who extended?
I say
Neighbor. Huh? Silk house. Right position. Okay, silk house. Because
thereafter I applied for extension of mine.
okay, okay. So it's only for making a wall. Both sides. The roof is already there.
And
Then so they said 1 lakh.
thereafter It was
Okay, so it was reduced, not minimized. You don't minimize rent. It is reduced to 75,000. Then to construct the wall at your own cost. Time period was given to you. Where is that letter? One lakh 5,000.
and thereafter, my lord, I made one is part.
So you asked for, that you asked that you be allowed to deposit, uh, security deposit of 70,000. 70,000 out here. Yes.
Now, my lord, all open again. I have to phone check, check for the, but, but it is.
Granted to whom? Given to whom? Are not granted, allotted you mean. But the space behind your shop was allotted to this, Hazarika chamber. Hazarika chamber, lawyer chamber or what?
Thereafter, I just is prior to some
Some discussion between whom
thing, come to some,
and Hazarika? Or did they discuss themselves?
because as I,
Okay.
I
Then,
know nothing about
then what happened?
this, but this, but
Okay, so page 30 is is that Hazarika's application.
some,
Unfortunately, they are all in vernacular. I cannot read.
but, second, first, is second, my, or my, that, that, basic. So this, you are, like, they directly for the,
So you're challenging it. So you're challenging it.
yes. Thereafter, the, I have but, but,
The records are in Assamese. Let it go to some other page. No point. I will not be able to understand. You see, but one thing, Mr. Council, one thing, I'll just say. That space was allotted to you in 2009. You made your letter in 2014. And in 2016, it has been allotted to that person. For 7 years, what did you do?
And my lord, it was a conditional order.
The
Subject
problem
to
is
payment of.
the problem is going to be in Assamese. I'm not going to understand what is it.
Payment of my lord, the rupee.
I know. I can gather from here.
And in that order, it says it is mentioned that it will be cancelled without further notice. Yes,
Mention,
in that order.
but it's in Assamese.
But he has my lord translated, and in that translation also your lordship.
Oh, it is there.
What is-
Is it translated? If it's translated, it's okay. But if it's not, then it might not be safe for me.
Lordship, okay.
That is the problem. But you see, you have been given the opportunity
Yes.
to pay the money from 2009.
Nine.
You have not paid for 7 years.
More than 7 years.
Huh? Then how long do you need to pay? You don't want to give the money. You don't want others to have the property. Now naturally now.
Lordship, in that, it is, Malak, in page 22, he has translated, if you agree with the opposite terms, you are asked to deposit the
Page
determined amount
22.
22 of money within time. Otherwise, allotment order might be cancelled without any notice to you. He has stated might be, but it is stated that it will be cancelled.
Where, which number?
Page 22, Lordship.
Yes.
Last paragraph here, that's stated.
If you agree with the first term,
Uh,
you are asked to deposit the determined amount of money within time.
Right.
Otherwise, the allotment, what is the time limit? No time limit.
30 days.
What is there?
Yes,
That's
ma'am.
not mentioned there.
Yes, Lordship. Paragraph 8. Paragraph 8 in that letter, my lord. For the office,
And then you see out here in this letter of 2014,
my lord.
he has asked for time to pay this 70,000.
My lord.
Why it was reduced,
In-
the amount payable.
Within time it was stated. 991 is the 9. Reduce, my lord. Is to deposit 1,05,000
Correct,
within 30 days.
correct.
And it is reduced. It is not, my lord, increased. So
Ah.
he could have deposited within
When
time.
was it reduced?
Reduced
Just a minute, one at a time. It's not a fish market.
3rd of February, my
3rd of February, which year?
2009.
2009.
9.
It was reduced to 70,000.
70,000. Within 1 month,
And he did not pay then also.
Mal.
And what does it say on the reduction?
On the
What does it say? Any letter given to him that it has been reduced?
yes, reduction letter is right now.
No, what is the document given to him? Is there any document, any information given to him that it has been reduced to 70,000?
I'm not getting that particular letter, but
No, anyway, he has
that is 3rd of February.
3rd of February.
Within time, Malak, it has been decreased, not increased, Malak.
Ah.
So he could have, Malak, deposited, Malak.
So that is why he has asked for time to pay in
Within
2014.
14 months. And we need rent also, Malak.
Huh?
He has enjoyed the space, Malak.
Oh, he has interest, huh? I don't, no, but
Okay, Malak, that is.
he has not constructed the
He
wall.
has not constructed,
He has not constructed the wall also.
Malak. So opportunity was given.
Yet you have to pay. So,
He did not avail the opportunity.
communication, there is no communication lab. There is a problem with it. You did not give that within time.
16 pilot has been allotted. After 7, more than 7.
Huh?
So the third person enters here. By contract, he puts, uh, I would take a call. So this was the fair so. So if I extend it, of the back side, I can open it. Other things.
But you're not opening it.
But this,
You're not paying the money.
but our first word of good second. And fight of this.
Can I just show me this, you see, this request made by this doctor
My,
for the vacant
space,
portion,
yes,
that letter dated 25/4/2016.
yes.
Is it in English?
It is in it.
And no, but
But
the,
letter portion, my
yes,
is
the
Assam.
comment, what are the comments just dated,
It's Assam is
just translated?
translated.
I don't want his translation, I want your translation.
Here, my lord, it is not translated, my lord.
Yeah, so you just translated while reading it.
Abedan by Victoria Matsuba, Gurupot, Matsupat, the person who is my lord, that Vijay Kumar Hazarika, the plot, my lord, now wants to be my lord, wants that it was earlier my lord allotted to Jiten Deka, কিন্তু এই আবণ্টনৰ বিপৰীতে but against this allotment, the payment, the security deposit. He did not submit the deposited the security deposit. গতিকে এই বিষয়টো নিম্নভাৱে আবেদনকাৰী আবণ্টনৰ মাজত so it was placed before the committee to take a decision. So on receipt that application that it was placed before the my lord committee for taking decision because yet we did not submitted the security deposit till 2016.
Another
And
thing,
even
Mr.
monthly
Council,
was not paid.
another thing. You have not annexed in your writ petition your application to the Dumduba Town Committee for reduction of that amount to be paid. Is it here in your petition?
He did not apply for reduction. It was reducted by the reduction was
Reduced.
done by the committee,
Itself.
my lord, committee.
Was that communicated to him?
Not-
Was it communicated to him that reduced amount?
That particular the letter is not there, but he knew it, my lord. Some letter.
No, he
after-
knew it, that's for sure because his letter is there. He's
No, my
asking
lord,
for time.
my lord, some communication is there by though it is filed by Jiten Deka and it was allotted in the name of Jiten Deka, but Dhiren Deka is my lord, is in all communication, my lord. Dhiren Deka, the brother of Jiten Deka, is in my lord in all communication made by Dhiren Deka.
Acha, it
Is
is
the
not by
brother
the
of Jiten
petition.
Deka.
Huh?
The brother of Jiten Deka is in my lord, in all communication made by the Dhiren Deka. Your lordship will find in the description also by the brother, not by the all my lord, all communication.
Okay,
Dhiren Deka 37 page 37 also my lord Jiten Deka for
Where?
Jiten Deka.
Huh?
Dhiren Deka for Jiten Deka. The other.
maybe he does,
I'm not saying
maybe he does not know how to write.
my lord, my lord. I'm not saying that, my lord. In all cases, my lord, a notice was served upon Dhiren Deka, brother of Jiten Deka. But he was given opportunity more
He
than
had enough
7 years.
time, yes.
More than
Yes,
7 years, my lord.
Uh,
And deprived by the town committee has been deprived by the rent also, my lord. If it was my lord, if he deposited 70,000 in due time, that my lord, rent will also be my lord getting, but he did not submit.
When did you know that you were supposed to deposit 70,000? Two thousand? 2016, and you were allotted the land when?
2009, 9-1,
9.
9-1, my lord, that is also what, January month.
Whenever these small things are going. Some people are there, some notes are there. Otherwise,
There is nothing to contest.
Because of their
He has no right over that, my lord. He was given more than 7 years.
But
At
he was not a regular member of tenancy,
Now,
not a regular member of tenancy. So when it part of the reason. So even if I cannot take it, so in a open, some other person cannot pay, then it pays. I seek rent a would expiry. Second, but I. I.
okay, so this, he has not, within 30 days, he has supposed.
Yes.
But then, that was reduced to 70,000.
70,000.
So when was the 70,000 to be paid?
That-
Within what amount? Within what date?
But the time was not, my lord, extended, probably from the reading, my lord, I did not say.
No, just read.
Okay.
Yeah, that's why you have got to read the record.
That particular deduction order is not here.
It has to be in the office note or somewhere. And then what is the time period given? So that is what.
In office note, my lord, in this side,
Okay, anyway, will you read it because I cannot read it.
my lord,
Oh, what? We'll fix it again.
lord,
If you read it and if you can show me where it is,
my lord.
then we'll decide.
Lord.
When was it reduced? And when was that communicated to the petitioner? That's all. On the prayer, the parties list the matter. After a week. After a week. Right.
This is the document.
But you've got to read, madam. Our
That
problem, I cannot
I
read.
want to, my lord, that reduction letter I cannot find. My lord, I'll have to ask for from there, my lord, so more time is,
This is the matter after 3 weeks.
lord.
Give a date.
That letter reduction.
That reduction, when was it made? Was that communicated to him?
My
And that.
lord,
Miss Gayan, that matter we have disposed of. One matter we did not. Because one matter, that order has been there also, promotion also. The other, so we left it. I don't think there's no other time. Right, out here, who is there? Mr. Das Gupta. So we adjourn the matter or what? What is this matter? No time. I've got a meeting at 4:30. Uh, yes, any other? Are you? No time. Okay, in this case, you're right. Due to paucity of time, this is the matter to see. Right. Okay. This is the matter after 2 weeks. It's in order to continue till the next week.